Tricia, help you got?
I do.
Okay, go ahead.
Your Honor, on May 24th of 2025 at approximately 3:33 a.m., Sergeant Mott was dispatched to the intersection of Hickory and Willow Grove in Televalley in Brownstown Township for a possible traffic accident involving a pedestrian. While en route to the accident, dispatch advised that there was also possibly an abduction of a female involved with the traffic accident. Upon arrival to the scene, Sergeant Mott located who was later identified as victim Jordan Damron, lying on his back, and a witness, Mackenzie Damron, standing over him. The victim, Jordan Damron, was bleeding from his mouth and was unresponsive, but was still breathing. The Brownstown Fire Department arrived at the scene at the same time as Sergeant Mott and began treating him. Sergeant Mott spoke briefly with the victim, Jordan Damron, while he was being treated by the Brownstown Fire Department. Jordan Damron is the brother of the witness that was standing over him, Mackenzie Damron, and I'm sorry, that is his cousin, and he is the brother of another witness to this incident, Carly Damron. Sergeant Mott asked Mr. Jordan Damron if he could tell him what happened. Initially, victim Jordan Damron told Sergeant Mott that he could not tell him what happened, but stated that Jamon Jordan Higgins had a gun. Victim Jordan Damron then told Sergeant Mott that Mr. Higgins had assaulted him, but was not sure if Mr. Higgins had used the gun to assault him. Sergeant Mott asked the victim Jordan Damron to describe the handgun, but the victim Jordan Damron was unable to do so. Sergeant Mott asked victim Jordan Damron if he was certain that he was assaulted with a handgun, and victim Jordan Damron stated he was certain it was a handgun because Mr. Higgins had the handgun while victim Jordan Damron came outside. Victim Jordan Damron also stated that Mr. Higgins was waving the handgun around when Mr. Jordan Damron came outside. Prior to speaking with victim Jordan Damron, the Brownstown Fire Department personnel were attending to his injuries in the ambulance, and they advised that the victim had injuries to the back of his head and to his ear. Sergeant Mott further observed that Jordan Damron had a swollen face and blood coming from his mouth. Sergeant Mott also spoke to witness Mackenzie Damron about this incident. Witness Mackenzie Damron stated that Mr. Higgins came to her residence located at 23697 Hickory Drive in Brownstown prior to this incident occurring to pick up Carly Damron, who is Mr. Higgins' girlfriend and the mother of his children. Witness Mackenzie Damron stated that Mr. Higgins is a very jealous person and began arguing with Mackenzie Damron and Carly Damron. She stated that victim Jordan Damron came outside at some point during the argument. Mackenzie Damron stated that she began to walk away from the incident to get away from Mr. Higgins, but as she entered the residence, she turned around and came back to where the argument was taking place outside, where she located victim Jordan Damron lying on the ground on his back, bleeding. She stated she did not see the assault, but she did see Mr. Higgins running away from where Mr. Jordan Damron was on the ground bleeding. She stated that Mr. Higgins got in an unknown vehicle and fled the area. Witness Carly Damron, who is the sister of victim Jordan Damron, was also interviewed. She stated that she had been at the bar earlier in the night with victim Jordan Damron to celebrate his birthday. She stated that she and victim Jordan Damron went to witness Mackenzie Damron's residence at 23697 Hickory, and that upon arrival, or shortly after their arrival, Mr. Higgins showed up at witness Mackenzie Damron's residence. Witness Carly Damron said that Mr. Higgins knew where she was because he tracks her location with her phone. She stated that after they arrived at Mackenzie Damron's residence, Mr. Higgins showed up and began honking the horn of his vehicle for Carly Damron to come outside. Carly Damron stated that she went outside so that she could leave with Mr. Higgins because she knew that if she didn't, that situation would escalate further. Carly Damron stated that when she went outside, witness Mackenzie Damron followed her. Carly Damron stated that Mr. Higgins and Mackenzie Damron began arguing, and during the argument, Mackenzie Damron began to leave and go back inside the residence. Witness Carly Damron stated that she got into Mr. Higgins' vehicle, an unknown silver Chevrolet. She said that once she got into the vehicle, Mr. Higgins also got into the vehicle, but then got back out, and that when Mr. Higgins was getting back out of the car, she heard Mr. Higgins chamber around in Mr. Higgins' gun. She stated that she saw Mr. Higgins walk towards victim Jordan Damron, but did not see what occurred between the two of them. She stated that Mr. Higgins got back into the vehicle, and Mr. Higgins told her that, quote, "I knocked him out." Witness Carly Damron went on to state that she does believe that Mr. Higgins would have used a handgun to assault victim Jordan Damron, but she was uncertain if Mr. Higgins used the gun to assault Mr. Damron during this incident. Sergeant Mott requested that dispatch run a check of Mr. Higgins to determine whether or not he had any registered firearms. The results did show that Mr. Higgins had a CPL and 2 handguns registered to him, a Springfield Armory XD9 16-shot semi-automatic pistol, and a Keltec PF9 9-shot semi-automatic pistol. Following the initial investigation, Officer Walker traveled to Coral Trenton Hospital, where he photographed victim Jordan Damron's injuries. While at the hospital photographing those injuries, Officer Walker made contact with witness Anna Damron, who identified herself as victim Jordan Damron's mother. Anna Damron stated that following this incident, her daughter, Carly Damron, called her and told her that while she was still in the vehicle with Mr. Higgins, Carly Damron told Anna Damron that Mr. Higgins had struck victim Jordan Damron with a baseball bat. Witness Anna Damron stated that she heard a male whose voice she recognized as Mr. Higgins in the background state that he did not hit him with the bat, he hit him with his gun. I was subsequently assigned to provide additional investigatory services in this case, and I spoke to witness Anna Damron, victim Jordan Damron's mother, by phone. During this conversation, witness Anna Damron had reported that the doctors treating victim Jordan Damron diagnosed him with a subarachnoid brain hemorrhage and 2 fractures to his jaw. Witness Anna Damron reported that her son was also experiencing pain in his ears and that his jaw had to be wired shut due to the jaw fractures. Witness Anna Damron also expressed that the doctors had indicated to her that the injuries were likely caused by blunt force trauma from a foreign object, potentially a firearm. They also provided several different screenshots of text messages. I was unable to interview Jordan Damron directly due to his jaw being wired shut.
You know what? I've heard enough to authorize here. I'm going to indicate that you sent the complaint over and dated it yesterday. I'm changing the date to today since we did the signing on record today, August 12th, as opposed to yesterday. Based on your sworn testimony, I find that the crimes of assault, intent to do great bodily harm, less than murder, and felony firearm were committed. There's probable cause to believe those crimes were committed by the defendant. I'm unauthorized. I've signed the complaint and the warrant, and we'll put that warrant in the lien. Thank you very much.
Thank you, Your Honor. Have a good day.
Thanks a lot. Okay, so Community Financial versus Adam P. Tilley.
Your Honor, there is no service on that, but we were checking this morning, so that one is not going to go.
Okay.
It was a discovery subpoena.
All right. Versus Adam P. Tilley, 2402248. I'll just indicate service not accomplished, reschedule. All right. Midland Credit versus Tennell Gardner, 2500576. All right. Ms. Gardner, your name, please. You're going to have to unmute.
Hi, Your Honor. Tennell Gardner.
Okay, you need to keep your voice up. Get nice and close to that device for me. You're muffled so slightly. Who is here for the plaintiff on this one? Is anybody here?
Mr. Monroe. Sorry, he's unmuting right now.
I'm there now, Your Honor. David Monroe, P18081.
Do you guys want to go into a breakout room and talk?
Been there already, Your Honor.
No resolution?
No resolution.
I think it's pretty clear that she has the right to have the case arbitrated, don't you, Mr. Monroe?
Absolutely. The issue is not whether she has the right to have it arbitrated. It's a question of who has to pay for it.
Well, do the documents, indicate? I didn't,
In fact, Your Honor, they do not.
Your Honor, as I was reading and did my research, I looked up the
nice
clause.
and loud, ma'am, nice and loud,
I'm
please.
sorry, can you hear me now?
Now I can hear you better.
Okay, I had to get closer. I did my research and looked up the contract, and it states that if I can't pay for the arbitration fees, which I can't, that I would have to sign a written request stating that I can't pay. And
Tell me what provision you're on in the arbitration agreement, ma'am.
it says the
Tell me what
location-
paragraph, what number?
I'm sorry, it's number 8. 8. Location and cause.
Do you work?
No, I don't.
Well, counsel, I don't know that I really need to address that. It seems like that's going to be something taken up with the Arbitration Association. So all I'm going to do here is order that the case be dismissed without prejudice. I'm not going to stay the proceedings. There's no reason for that. For the reason that the parties are to submit to binding arbitration in accordance with the arbitration clause from the Community Bank cardholder agreement. So I'm just going to ask you to submit an order. You can file that, and the Arbitration Association can take that up and decide whether or not she can pay and who's to pay the fees. I think that's something where I'm putting the cart before the horse. She says she doesn't work. There is a provision here that if you can't pay, and put that in writing, I guess I can quote it, we will pay them for you. Parties shall pay filing, administrative, and arbitrator fees in accordance with the administrator's rules and applicable law. However, if we receive a written request personally signed by you stating you cannot afford to pay your portion of said fees, we'll pay them for you. So I don't think this is anything for me to address. So I'm simply going to ask you to submit an order.
May I please appearance to the record for the point?
Okay, I got to have somebody muted here, whoever it is.
Good morning, Your Honor. This is Attorney Mr. Farmer is asking.
I'm sorry, Your Honor. I'm on 2 cases at the same time.
That's okay. So I'm going to ask you to submit an order dismissing the case for the reason, and without prejudice, for the reason that the parties shall submit to binding arbitration in accordance with the cardholder agreement.
With respect, Your Honor, I disagree with that ruling because arbitration, according to the contract, is optional on both sides, and plaintiff made its option to bring the case before you. So if she wants,
well, that doesn't mean so. If you make the okay, so you can point out the provisions of the agreement if you want. That means that you're completely dismissing the option of the defendant to go to binding arbitration, aren't you?
Well,
you can't say it's optional, plaintiff filed here, so therefore it has to remain in the 33rd District Court. If you want to point out the paragraph, I'll be happy to read it.
Your Honor, it's not a question of what the contract says that way. The question is, once it's been filed before you, she has the option to remove, but if she wishes to remove, she bears the burden.
Tell me where you see that in the contract. What provision?
Doesn't say, Your Honor, it doesn't say either way. It just says both parties have the option. We've already spent some money filing the case before you.
Wait a minute, slow down. I need you to point to the paragraph here. I didn't see any objection. Maybe I'm wrong. Maybe I misread your response. You're saying it's not cost effective. I didn't write the agreement. The cardholder wrote the agreement. If they don't want to have that in the agreement, they better take it out. Either party may elect to move the case to arbitration. And I've got a provision saying if she can't pay the fees, she can submit that in writing. If you want to take a minute and look at this, I'll be glad to listen to you, counsel, but I don't see it. It might be more cost effective.
Judge, it looks like we may have lost him.
I don't know what to tell you. Ma'am, stay there. I'm going to let him point out the agreement. Don't go anywhere, please. I'm going to recall that as soon as he comes back in.
Okay, thank you, Judge.
Synchrony Bank, Synchrony Bank versus Virginia Plemons, 2502214. Good morning, Mr. Filkins, your name?
Yes, good morning, Your Honor. John Filkins, P70263, appearing on behalf of Virginia Plemons, who's appearing remotely by Zoom as well.
Ma'am, your name? You have to unmute. Who is here for Synchrony Bank?
Judge, I have not had anyone check in for Synchrony, and I called and was on hold for 5 minutes trying to get a hold of someone.
It's always these firms out of other states, you know that? I don't know what to tell them. Maybe they shouldn't be practicing law here if they're not going to show up. I mean, what are we supposed to do? Well, I mean, they've waited. It's 9 o'clock. The case was scheduled for 8:30. I'm going to go on to a couple others, and then I'm coming back and going to see if the lawyer showed up, but we're not their secretary. This is a Wisconsin law firm. That's fair. If they're licensed here, they can practice, but they still have to practice like everybody else practices, not like they want to practice. LVNV versus Vicky Essenmacher, 2502703.
Good morning, Your Honor. Stephen Couch, P75833, appearing on behalf of plaintiff.
Good morning, Ms. Essenmacher. Your name?
Vicky Essenmacher.
Good morning.
Good morning.
I don't know what to say. Did you guys talk about this? You're saying there was fraudulent use of a credit card, ma'am?
Yes. Yes. My husband and I were in the hospital both with COVID and the Trenton Beaumont at that time. I gave my husband my ID, my insurance card, and my social. He ended up passing away. I went back to go get my credit cards and all his belongings and everything he had. And they said that it went to the funeral home, and the funeral home said it went to the hospital. So it went back and forth. And then what ended up happening is I had to file a police report, which I did, and gave this credit card company 2 or 3 different occasions, which they said they were going to take care of, but never did. So I've been going.
Is this a joint credit card that you and that your husband owned together?
No. What happened was about 4 or 5 months after he passed away, I started getting a bunch of different credit cards in his name and my name, and I'm like, what the heck is going on here? So I was told I should go file a police report. So when I went down to Trenton to do so, the gentleman, the police officer there, told me he had actually arrested 2 janitors for stealing from people. So that was at the time what happened. So I gave them the police report, and several times they told me a supervisor would call me back, and no one ever would. And then when I would talk to one, it was constantly just a runaround. And then the balance also said it was only a 500 limit, and they're trying to charge me 3,500. So I'm it's just been really stressful.
Mr. Couch, have you looked into this at all?
Your Honor, I'm appearing today on behalf of Counselor Record. My understanding from what they've provided to me is that the account was opened, that there were 1 or more payments made on the account, and then at some point the payments stopped and it went into collections. That is the extent of the information I have on this one, I'm afraid.
Well, I can't resolve this today. I understand what you're saying, ma'am. I'm going to give you guys discovery. Now, I want you to understand that you're going to have a difficult time here, ma'am, representing yourself. I understand it may be cost prohibitive to hire a lawyer,
Yes.
but I can't appoint lawyers on civil cases of this nature, okay? I don't have the authority to do that. So what I'm going to do is I'm going to give you guys discovery. Discovery is the exchange of information. If they have documentation that you want, you can request it in writing. If you want to send them written questions, you can do that as well. Okay? I'm going to go ahead, Mr. Couch. What's your P number, sir?
75833, Your Honor.
Okay, thank you. So, ma'am, I'm going to go ahead and give you some dates. So I'm not going to order ADR on such a case. There's just no reason for that. I'm going to give you guys discovery for a period of 60 days. You can conduct discovery here. That's the exchange of information, again, as I said, until October the 17th. October the 17th. No motions will be heard on the date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. I'm not going to order a settlement conference. I'm going to put down 1/2 hour. You have to file your witness list by September the 17th. September the 17th. And I'm going to give you guys a trial date here momentarily. So Jennifer, why don't you, and I'm going to cover a couple other things with them. Why don't you give me a date in the latter part of November, please? So Ms. Assenmacher, you didn't really answer the complaint appropriately. You're supposed to go through each allegation and either admit it, deny it, or neither admit nor deny for lack of sufficient information.
Okay.
You can't just write in letters here. I'm not going to make an issue of it, but if he files a motion for a more definite statement, I'm going to grant it. Okay? So that's the best way I can put it.
Well, I will tell you the reason that some of the payments were made was because I was just paying everything at the time. I wasn't really.
Let me ask you a question.
Yes.
Did you review the charges?
Yes, and none of them. There's a lot of them were out of state. I wasn't out of state. I was on oxygen in my home. I couldn't even leave my home or drive, let alone worry about credit
Mr.
cards.
Couch, I've been doing this a long time. I tend to believe, or I'm not suggesting you should dismiss your case now. I am suggesting that you should look into this, please. Okay? Send him, do you have the police reports, Mr. Couch?
I don't, Your Honor, but I will.
Can you send
I'll forward
those
that
to-
along.
You have the police reports, right, Ms. Assenmacher?
I don't because I sent the original, but I can go there and get another if I have to.
I'm going to let you two talk about this, conduct discovery. I'm going to give you a bench trial date, and we're going to go from there. But it does seem to me like she's being honest and sincere here. You don't have to file a trial brief when it comes to that. If you choose to file one, it has to be filed later than 7 days before the trial date. Go ahead, John, give me a date at the latter part of November or the first week of December, please.
Judge, we can do November 17th or December 1st, which would be better.
Let's do December 1 at what time?
10:30.
10:30, and we're going to set others at 10:30 because I have a feeling this will resolve. Okay? So 10:30 so you can write that down. We're going to prepare a pretrial order. We're going to send it to the two of you, and we'll go from there. Okay? Anything else, Mr. Couch, on this one?
No, Your Honor, thank you.
Ma'am, anything else? Any questions or anything?
No, I appreciate your time. Thank you so much.
This is just a pretrial right now, okay? All right, thank you very much. Midland versus Gardner, 2500576 GC. Mr. Monroe, your name again?
Yeah, David R. Monroe, P18081, Your Honor, and I apologize. My machine kind of fell out on me, and I'm back now.
It's fine. Ms. Gardner, where are you at? There you are, ma'am. Your name again?
Tamel Gardner, can you hear me?
I can.
Okay.
All right, now, counsel, I don't want to hear anything other than you telling me what portion of this says that she can't have the case removed. It's at the option of either party. You even said it in your brief.
I agree, Your Honor. The question is, who pays for the arbitration?
I'm gonna let the Arbitration Association deal with that. I just read you the provision.
I understand that. What
If
I'm
she
saying,
said, I don't have a letter from her. Look, you guys wrote the contract. If you wanted to say that, and it's your client wrote the contract, she didn't write the contract. That goes back to Contract 101. If there's a provision that's ambiguous, it's to resolve against the drafter of the contract. That's the extent of my order. Please submit an order that's. Counsel, you got to turn that off for me, please.
I just did, Your Honor.
Thank you. Submit an order. Case
Okay.
dismissed without prejudice for the reason that the party shall submit the binding arbitration. Thank you.
All right, thank you.
Thank you.
Thank you, Your Honor.
Where is that one that I called?
Synchrony, is that the one?
Yeah, where'd I put that one at? Come on. Here. Where'd I put Synchrony at? Okay, Synchrony Bank. Are you on this one, counsel? The other one, Mr. Royce? No. You know what?
Your Honor, I've tried calling again and was going through their phone system for 5 minutes again and with no answer.
I mean,
Your Honor, is Mandrich Law Group on the caption?
No, it's Rausch and
this is out
Sturm.
of Wisconsin.
It's Rausch and Sturm.
It's Rausch and Stern. I see. Look, Riki, Leontiv, Eva, Sweet
When you-
200.
Yeah, when I call the number that's on the summons, it indicates it's the Rausch and Sturm law office.
Yeah, Rausch Sturm. I see. Did you leave a message?
Judge, I can never get to a voicemail to leave a message. It would just kept transferring me from.
Recalling Synchrony Bank versus Virginia's Plemons, 2502214. Your appearance again, Mr. Filkins?
Yes, John Filkins, P70263, appearing via Zoom, along with my client, Virginia Plemons, who's remotely appearing by Zoom as well.
Well, they failed to appear. I'll be glad to dismiss the case without prejudice if that's what you want, or I'll reschedule it. Either way, I have a feeling if I dismiss it without prejudice, they're going to file a motion to set it aside, and we're going to be back to square one. But I'll do whatever you want.
Your Honor, at this time, I would ask that the matter be rescheduled, that the court consider in the future any award of attorney's fees as a result of my having to appear.
I will. Reschedule this. Attorneys failed to appear. Issue of sanctions preserved. You can bring that up on the next hearing date, Mr. Filkins.
Thank
Your
you.
Honor, we can do September 8th at 9:30.
Your Honor, I will tell the court I am leaving out of the country September 1st, returning on September 22nd. So if it's possible to have a date after.
Good enough. Give me a date after that, if you would, Jennifer.
That would be, well, we have the 22nd, so he's not going to want to be here that day. October 6th.
I'm looking at
That's a long time. Can't I do it the week of the 29th or anything?
I mean, it's probation. Do you want to throw it on at the end of your probation docket at 11?
No, I want to do it at 8:30 that day.
8:30?
What
Okay.
day is that?
It's a Monday.
I know, but what date?
28th, I'm sorry.
September 28th at 8:30 we'll reschedule this for, okay?
If I could just make a suggestion here, according to my calendar, September 28th is a Sunday. I may have.
Oh, 29th, I apologize. I looked at it wrong.
All right, so September 29th at 8:30.
Yes, will be the pretrial.
Understood. Yes,
All right. Thank you very much. Have a good day. Good luck, ma'am. Thank you.
Thank you. Bye-bye.
All right. I don't understand some of these lawyers anymore. I don't get it. Velocity versus Jessica Oshalak, 2501828.
Yes, Your Honor. Chris Royce, P49102 on behalf of plaintiff.
I'm sorry, P49102?
Correct, Your Honor.
Okay, is Ms. Oshalak here?
Judge, she was briefly. I had placed her in a breakout room and tried to put Mr. Royce in with her, and she is gone now.
Oh, yes, Your Honor. We did speak in the breakout room, and she agreed that we should just do a 60-day discovery order. She's working with a debt settlement company. I usually tell them that we have to go back before the judge. I failed to do that this time. She may have disconnected.
Jennifer, call her up, 795-5578, 795-5578. Get her back here, please. Hamptons versus Amna Khan, Salim Khan, Sana Salim, Azra Khan, and Hyra Khan, 2502119.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Are any of the individuals here? Sir, your name, you have to unmute, get your face up nice and close to the device and tell me your name.
Hi,
Mr.
I'm Hira. I have my family here. They don't speak English. My sister and I do.
Okay, what's your name, ma'am?
It's Hira, Hira.
You are a defendant. Who's this one next to you?
It's Amna.
Amna Khan and Hyra Khan. Okay, I have you two.
And my parents are here, but they don't speak English. I have Salim Khan here, and I have Azra Khan here.
Hi.
And then my sister, Sana, is also on Zoom through her phone.
Oh, boy. Okay, all right, good enough. Sana does not speak English either, correct?
They can understand, but it's not their first language, so I don't know if she would be able to explain.
What does she primarily speak?
Urdu.
Urdu, okay. Ms. Khan, I need you to unmute, or actually, yeah, Ms. Salim. Her last name is Salim, correct?
Yeah, yeah.
Okay.
Sana and
And can you tell me your name?
It's Sana Khan.
Well, actually, your last name is Salim, right?
Yeah, it was Salim, but after citizenship, I just changed my name. I did it Khan.
I see. Okay. All right. Now, could you have Azra and Salim Khan kind of appear in that box there and tell me their name?
Yes. So this is Azra, my mother, Azra Khan.
How you doing, ma'am?
Hi.
Can you tell me your name?
No.
Azra Khan.
And sir, your name, please.
Yes,
Naam batana.
Salim Khan.
Good morning. How is everybody out there? Good?
Good.
Good.
All right. Now, where do I go from here except to say, did you read the response, Ms. Austin?
I did, Your Honor. I did, Your Honor. And I know it's not a formal answer, but I would have to accept it as an answer. I'm not going to file a motion for a more definite statement. But if we could get maybe 60 days of discovery, maybe we can get this resolved. So they moved out before the end of their lease term, and that's the gist of the complaint is that, you know, they owe the 2 months for.
Right. Okay. I want to try to explain something to you, Hira and Amna. And I want to make sure that I'm doing a good enough job here to explain it to Sana and your parents.
Okay.
If I need to have you have to interpret, you tell me.
Okay.
Now, it appears as though your answer, your letter, acknowledges the debt. In other words, you seem to be saying in here, we cannot afford the 2629 being requested. Now, if that's the case, there's no reason for me to set this for trial. If you agree that you owe the debt, what could happen here is I can put you in a breakout room with Ms. Austin. Maybe, I'm not trying to put words in your mouth, but maybe you agree to a judgment and we set up a payment plan that everybody can live with. Nobody wants you or your family not being able to eat or pay rent or pay the essentials of life, okay? So a lot of this depends on who's working, how much they're making, where you're living now, what kind of bills you have. Do you have a car payment, a cell phone payment, a house payment, a rent payment? Those kinds of things. Am I making sense?
Yes. I just want to understand one thing. We thought that the security deposit and the last month rent that we left would cover the whatever the remaining thing was when we were leaving. So did that not count towards the remaining balance?
Did you apply the security deposit, your client?
There's a security deposit of $680 that was applied.
Were there any damages?
It looks like they had to replace it for $444 due to red, dark.
What?
And again, maybe, Your Honor, maybe a 30-day adjournment. And I missed Hira Khan's email address while we were in a breakout room before we came to see you.
All right. Look.
Send her what I have. We can try to work out a payment arrangement, come back in 30 days, see you, and hopefully.
I have no problem with that. I'm going to adjourn this pre-trial. Jennifer, give me a date, but I want to make sure I'm explaining things appropriately for you two, okay? She's saying they applied the security deposit, but there's some kind of $444 charge. Can you tell me what that was for?
It looks like some carpet was replaced, Your Honor. I have some photographs that I'll send her as well.
Okay. How old was the carpet, though? I mean,
I don't know how old the carpet was, Your Honor.
Well, I know, but here's the thing. They don't get to go buy new carpet and then stick the tenants with the whole charge either, right? It's depreciated.
The value of the old carpet. I appreciate that.
Thank you. But they don't like to do that. They got to have guys like me ask questions and make sure it's done right. But I'm just going to leave you with that thought. Here's what I want to tell you two ladies. This is a courthouse, a courtroom. If we hired a painter and this carpet was 25 years old and they didn't put down drop cloths and we had to replace it, we'd only get the value of what the carpeting's worth now before the damage, as opposed to coming in and buying all new carpeting. Okay? So I'm going to ask you to negotiate with them with that in mind. If I need to hire an interpreter at any time, bring in an interpreter for Urdu, I will do that. Right now, I'm going to adjourn this for 4 weeks. Okay. Give me a date mid-September, Jen.
September 22nd at 9:30.
Okay. So I'm going to make a note here. Sana Salim is now Sana Khan.
Yes, correct.
Amna and Hira speak English fluently. Is that true, ma'am? You think you speak that fluently?
Yeah. Yes.
And I want you to correct me if I'm wrong on this. Salim Khan and Azra speak some English,
They
but not fluent. Is that true or false?
they can just like greet and
I see.
yeah.
So we'll need interpreter on that.
Mhm.
For that, but I'm not going to bring them to the pretrial because then I got to charge interpreter fees and they're really expensive now. I don't know why.
If it's okay, we can translate to them.
I understand. So let's do that for the pretrial. You talk, translate with your parents, get Santa involved. I'm going to adjourn this to September 22nd at 9:30. And I'm going to hope that you guys can resolve this, okay? I will not conduct the pretrial now.
Okay, thank you.
Okay? Am I being clear at all, or do you understand what I'm trying to say here?
Yes.
How about you, Amna?
Yeah.
Okay. All right, good luck. We'll see you September 22nd, everybody. Thank you.
Thank you.
Thank you.
Honor.
All right. Velocity versus Oshalek. 250-12828. Your name, ma'am?
Jessica O'Shalley.
Mr. Royce, your appearance?
Yes, Your Honor. Chris Royce, P49102 on behalf of plaintiff.
Okay. Now.
Yeah.
All right. You don't think this is your debt, Ms. Oshalek?
No, it is.
Do you dispute any of the figures?
No.
Why are we even conducting discovery? Because of the debt settlement? I mean, you know.
I don't, sorry.
Go ahead. It's all right. But I'm not prepared to just have debt settlement companies hold up cases here. I mean, they're either going to come into the foray and get involved, or I'm not going to just keep putting things off and setting discovery. If you agree that, the debt, then maybe you can go in with Mr. Royce and resolve this.
Yeah, I thought I had payments set up since 6/13/25. So I wasn't sure why this even went to court.
Mr. Royce, have they been paying on the debt?
No, Your Honor. My understanding of debt settlement companies, they have them start paying, and once they get a pot of sufficient funds, then they contact to settle.
Well, that's nice.
There has been they have contacted us, but they have not even made an offer yet at this point.
Oh, of course not. They delay. I'm not prepared to delay. So I'm just going to set the thing for trial. That's what I'm going to do. You can have discovery if you guys want until September 26th. We're going to set a trial date in October. Witness lists are due on September 1st. We're going to set it the same, 1/2 hour again, Jen. I'll give you no jury trial demand, no nothing, no settlement conference. You don't have to file a trial brief. If you choose to, you have to file and exchange it not later than 7 days before the trial date. And that's it. So give me a trial date in mid-October. And I'll do that for you guys. I'll give you 35 days or whatever. Maybe you can get the debt settlement company moving, but I'm not going to hold my breath. Give me a date in mid-October, Jen.
October 20th at 10:30.
At 10:30, all motions for summary have to be filed and heard not later than 20 days before the trial date. She's admitting the debt. If you file your motion, I can't imagine me not granting it, assuming the appropriate documentation is in line. Okay, thank you both.
Thank
You're all
you.
set. Have a good day. Good luck, ma'am.
You too. Thank you.
All right, now what do I have up there? Do I have this Towering Construction, what time's that on? And S&D Investors?
Judge, I have University of Michigan that are in a breakout room.
Do you have the files?
And
Tabitha?
S&D Investors, the plaintiff is here. I have an iPhone that just logged in, so it could be the defendant on S&D.
Showering informal.
You have that, Tabitha?
On the iPhone, can I get your name, please?
The iPhone, you need to unmute and put your name on there so we have a clue who you are, okay? Unmute. Faizan Zulfikar Chowdhury.
Right to the podium.
25B148-998. Your name, sir?
Faizan Zulfikar Chowdhury.
Officer, your name?
Officer Cox, sir.
Good morning to both of you. Did you two talk? Do you want to try to resolve this?
Yes, sir. We come to an understanding. I'd like to move to just dismiss the ticket if you're okay with that.
If that's what you're comfortable with, it's just a prohibited parking. You're not gonna park there again though, right?
We worked that out, yes. No, we understand.
All right, case dismissed, motion to plaintiff. You're all set.
Thank you, sir.
Have a good day. Thank you. Good luck to you both. All right, who else do I have here? Sir, what is your name? You have to tell us your name.
Ladero Kerr Gardner.
Okay, S&D, let's do that one. Is anybody here? I thought they were here. Am I right or wrong? I thought you said somebody was there from S&D. Do I have anybody here on University of Michigan Credit Union versus Villarini? Jen, are you out there?
Judge, did you need something?
No, I'm good.
Okay, I'm sorry.
No, you're fine. You're fine. I just wondered, Jen had told me S&D Investors was out there. Mr. Gardner is here. Garner. And I don't know what happened to S&D Investors. And I don't know if we have University of Michigan Credit Union. It should be a lawyer, Scott Chernich out of Lansing. And
They are in a breakout room. The U of M Credit Union, they're in a breakout room still.
Where's S&D Investors lawyer? Should be either Daniel Goldman or Scott Mancinelli.
I will bring him in right now.
Okay, thank you. Mr. Goldman, you can start your video. This is S&D Investors LLC versus Ladero Garner. Your appearance, counsel?
Judge, I can't hear you.
You can't hear me?
1 second, please. What's going on?
I can hear you.
Forgive me, Your Honor. I want to test my. Oh no, what's happening here? Come on. Your Honor, can you hear me now?
I can hear you. Can you hear me?
Yes, Your Honor. It's a little, yes, forgive me. I can.
Okay, your appearance?
Your Honor, Daniel Goldman, 64231 for the plaintiff S&D Investors.
Mr. Garner, your name?
Ladero Gardner.
I read their answer, their motion, Mr. Garner. I'm inclined to grant their motion for a more definite statement at least. More motion, so that would mean that you have to either admit or deny each allegation in the complaint,
Okay.
or neither admit nor deny for lack of sufficient information. You can also assert affirmative defenses, but you can't just, you're almost admitting the debt here. I'm not in dispute of the debt ownership of the account, but if you're unable to provide the full report of how you validated, verified, and how you were in compliance, you must remove the account from my credit report. That's not appropriate for an answer. So here's what do you understand what I'm trying to tell you here?
Yes.
Mr. Goldman, I'm simply prepared to require the defendant to file an amended answer within 21 days.
Your Honor, I understand. Forgive me.
Go ahead.
Your Honor, we were here on July 15, and Your Honor, at that time, indicated that you would order him to file an amended answer with 21 days. No order was entered. We did file, Your Honor, a proposed order under the 7-day rule. I don't see that that was ever entered, but that answer.
I didn't realize that. My apologies here. Okay, see order I signed. Reschedule court date. Notify plaintiff attorney I will not be signing an order to the above effect. What is going on here? I need, hang on one second. Wait 1 second. Jennifer, you need to enlighten me here. What is going on?
I'm sorry, Judge. It's Linda.
Where's Jennifer?
She's dealing with Amanda Mount.
Well, Amanda Mount's going to have to wait. I mean, I don't have to tell her.
All right. I will get her right now.
Please.
Your Honor, if you would indulge me, I could tell you what I recall. I have notes.
Go ahead.
Thank you, Your Honor. So we were here on July 15. The defendant failed to appear. We asked for default. Your Honor took some time, thought about it, and then said, I can't give default judgment, but what I will do is enter an order requiring the defendant to file.
Hi, Judge. Sorry.
It's okay. Let me, I need you on this one. This is Garner, S&D Investors LLC versus Garner. It looks like go ahead, counsel. I'm going to let him explain. They were here previously. The defendant didn't show up. This is on the plaintiff's motion to strike the answer.
Your Honor, and so we requested default. Your Honor was going to grant that, then hesitated, then said no. Then Your Honor indicated.
Mr. Garner, hang on a second. Okay, you were in the hospital. I get it, but let him finish, and then I'll address all this. Go ahead.
Thank you, Your Honor. And then Your Honor indicated, but I will require the defendant to file an amended answer within 21 days. You said if the defendant fails to file an amended answer, then we can file our motion again. And those notes I entered at 10:57 a.m. right after the hearing.
Okay, so Jennifer, here's my notes on, that was July 15th. You were in the hospital July 15th, Mr. Garner?
Yes.
Okay, this is what I wrote on July 17th. I said, see order I signed, reschedule court date. Notify plaintiff attorney I will not be signing an order to the above effect. Motion will be addressed on August 12th at hearing. Why did I write that? Did we get some kind of note that he was hospitalized?
Judge, we got a motion from the defendant that they had a procedure and were going to be in the hospital.
Okay, all right.
And that crossed paths with the court date because of M-File. It was in a box waiting for signature.
So
all
that's
that
what happened. When I had the, when you appeared July 15th,
right.
He was in, hang on, Mr. Garner, he was in the hospital. So I'm not going to enter an order on somebody without them being present, particularly if they're in the hospital. Okay, so that's when I said I'll address all this today. So that's where we are. I'm gonna.
Your Honor, your legal assistant indicated a motion was filed. I have no evidence of a motion being filed by the defendant.
No, your motion. Your motion was.
No, Your
There
Honor. you
was
were
a
certainly-
motion by the defendant to adjourn that was filed, and I can look at the service notice. Give me 1 second. It was filed on July 3rd.
We don't have it. I don't dispute it. We just don't have it.
I understand. Listen, this M filing.
Yeah,
we've been
it was-
dealing with- Hang on.
It was downloaded on 8/4, it looks like, downloaded on 7/16, downloaded on 7/14. So it looks like a couple different people at Mandridge Log downloaded it.
All right. So what I'm trying to tell you here, Mr. Goldman,
Yes, sir. That's fine.
is I think my intent from what I'm reading in my notes now is that I'm simply going to go back and address your motion to strike your answer and enter default or for a more definite statement. And so I think I was right with what I said in the beginning, but I didn't know all these other events that transpired. So, sir, Mr. Garner, I want you to understand something. I'm going to order that you file an amended answer to complaint.
Okay.
Within 21 days. You have to, and I know you're not a lawyer, but you either have to admit each allegation, deny each allegation, or any combination thereof, or indicate that you do not have sufficient information to form a knowledge about whether the allegation is true or false, or whether or not it's to be admitted or denied. Do you understand that? If they
Yes.
alleged that you were in Tahiti one day, or somebody was in Tahiti and you don't know, you would say neither admitted nor denied for lack of sufficient information to form a belief about this truth or this averment. So you either have to admit, deny, or neither admit nor deny based on that ladder that I just went through. And you have to do that within 21 days.
Okay.
And then after you do that, did I ever conduct a pretrial on this?
I don't believe so.
No, Your Honor, I don't believe it ever had a pretrial.
This case been going on since April. So here's what I'm doing. Counsel, submit that order. You have to file an amended answer to complaint within 21 days. And I'm going to set this for a pretrial. So let me just make some notes here. Defendant to file amended answer to complaint within 21 days. Now, sir, if you don't do that, I'm going to give them a default. So I understand you're not a lawyer, but you have to be able to follow the rules here. I can't do it for you. We're going to also set pretrial for September what, Jen? Middle of September. Are you there?
Yes, Judge.
I understand. So about 4 weeks out.
Yeah, I'm just looking to see what we got here. The 8th. It would be September 8th.
Well, I want to get his answer before then. I won't have his answer. What about the 15th?
Well, that's probation, but if you want to add it in the morning, or
September
we can do the
15th.
22nd.
September 15th at 8:30, okay? That will be another day that you have to return, but you have to file your answer, sir, amended answer to complaint within 21 days. You'll prepare the order, Mr. Goldman?
I will, Your Honor.
Sorry for the confusion, everybody.
I wasn't trying to argue with you. Forgive me. I understood your ruling. I just wanted to clarify it. But
No, you weren't. I didn't take you as arguing. Listen, this M filing we've been doing for 2.5 years probably now, and it's no fun. I mean, it's easier for everybody else but courts. And I get it, but I only have half of a file here typically. I have some notes. The staff does a great job, but I just do what they tell me to do up in Lansing, Mr. Goldman. That's all we
I'll
try.
do what you tell me, Your Honor. I'll have an order under the 7-day rule.
Have a great day. Actually, you don't even have to submit it under the 7-day rule. Just submit an order today and I'll sign it. Mr. Garner, do you understand everything here?
Yes.
Good luck to you, sir.
Your Honor,
I
do you
hope
have an
you're-
email? Is there an email address we could send this order to?
Jen?
File it, please.
Very well.
Okay, thanks.
Thank you.
November Credit Union versus Michael Villarini, 2501493. Good morning, Mr. Quinn, your appearance?
Morning, Your Honor. Patrick Quinn on behalf of University of Michigan Credit Union.
Mr. Villarini, your name?
Michael Anthony Villarini.
All right, so you're suing for 6712, right, Mr. Quinn?
Yes, Your Honor. And actually, in our last breakout room, I think me and Mr. Villarini were able to come to a payment plan agreement. If we could maybe run that through the court and see if the court's agreeable.
Consent judgment?
Yep.
Good, fine. Go ahead and provide me with the terms.
Yeah, so I think we would start at $100 a month. And essentially, just for some background, Mr. Villarini is currently out of work and he's expecting a settlement from a workers' compensation injury. So I was thinking at 12 months into the payment plan, we review his ability to pay. If nothing changes, we continue on with $100 a month until the balance is paid off.
So give me the total figures here. What do you have, including costs?
$6,712, Your Honor.
You're not asking for any other filing or service or statutory attorney fees?
No, Your Honor.
So the total settlement, the consent judge will indicate 6712. Defendant to pay $100 per month beginning when? September 1?
Sure, Your Honor. I think that's, as long as Mr. Villarini is okay with that.
Yeah,
Can
I'm
you
good
do
with
that, sir?
Yes, I'll make it work.
I'm sorry?
I'll make it work.
And then, so you're also asking for a review hearing on the payment plan after 1 year?
Yes, Your Honor.
All right, this is what we'll do then, Mr. Villarini, and I want to make sure you're okay with this, Mr. Quinn. This would be a consent judgment in favor of the plaintiff and against you in the amount of $6712. You would have to pay $100 per month beginning September 1. The other orders portion of the judgment will indicate this payment order is subject to review on motion of either party on or after September 1 of 26. Is that acceptable, Mr. Quinn?
Yes, Your Honor.
Is that acceptable to you, Mr. Villarini?
Yes, Your Honor.
Does Mr. Quinn have your permission to sign your name to the proposed consent judgment outlining those terms?
Yes, sir.
Do you have any questions for me at all?
No, Your Honor. I just want this to be over with. Thank you.
I understand. I wish you a good recovery with whatever it is, and I hope everything works out for you. Best of luck to you.
Thank you, Your Honor. Have a good morning.
Thank you. Thanks, Mr. Quinn. Have a good day, gentlemen. Thank you. All right. What else do I have down there? Do I have Rosalino Gaglio?
He's in the courtroom. Right.
Do I have Angelina Jade Vila? Rosalino Gaglio versus Angelina Vela, 2502794.
Morning, Your Honor.
Good morning to you. Your name?
Rosalino Valley.
I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
I do.
So the defendant did not show up. I just want to ask you a couple of questions here. Did you, so you're saying the accident was her fault?
Yes.
Was she ticketed?
Yes, she was.
All right. Did you get your car repaired?
No, it was totaled out.
Do you have proof of that?
Yes, through my insurance company. Correct.
How much of so when they totaled it out, how much did they pay you?
They gave me $4,008.
Did they take off a deductible of $1,000?
Yes, they did.
So that's what you're out of pocket?
Yes.
And you're under oath. You understand that, right?
Yes.
Well, that makes this easy. I can always use an easy one, Mr. Gaglio. So I'm going to give you $1,000 plus you get your filing fee of $68. Did you have a service or process fee or did they sign?
What?
Wait a minute, Jen. Was this doesn't even look like it was signed by the recipient.
Judge, it was yeah, I know. They just drew lines. That was the signature. I mean, that's what.
What do you mean? Who drew lines?
Well, whomever signed for it. You have the, I know, that's all they did at the post office, required it.
How am I supposed to give this guy, gentleman a judgment when we don't have a signature card? Jeez.
You have the one that they submitted back to us, correct? That's what the post office sent back to us saying that it was signed for.
Well, what does that mean? John Joseph could sign for this thing. I mean, anybody could sign for this thing.
I know. Yeah, they just drew 2 lines across the recipient name and
Jeez.
and say that it was signed at that address.
Sir, I am really sorry. I cannot give you a judgment without proper service. There's not proper service. The defendant has to be served personally here. If this was a corporation, essentially on small claims, anybody could sign for it at the corporation. But there's not proper service. I will adjourn this, and you're going to have to probably get a process server to go out and find the person.
I'm the lady that hit, the lady who got ticketed is what you're saying, Ross?
The defendant, whoever struck your car.
Okay.
Ms. Vila, it looks like.
I had to go find them.
I can't enter judgments.
I don't know.
I cannot enter judgments against people that weren't properly served. I have rules I have to abide
No,
by.
I understand that. I figured it was a long shot at Judge because they went to get a Minotaur and the information she gave the officers is not true. She has no policy with Progressive that she claimed she had. So she basically fraudulently told them. And,
Yeah, I know.
I get the.
There's all kinds of people running around doing that kind of.
Well,
nonsense.
yeah, understandable. But I tried.
Well, you still can try to pursue this. You could get a process server and have him go out and find her. You know, presumably she's at this address. They can run postal inquiries. They can determine whether or not she's still there.
Do they charge for that? I mean,
Yeah, I mean.
Is it a significant amount or I don't know. I've never.
I mean, it depends how easy it turns out for them to find the person.
The person?
You probably, in a case like this, they live in Detroit. It depends, but you can count on paying, what would you say, Jen, between $68 and $120, depending on how much time, but I can't speak for process servers. They're independent contractors.
I get you.
I'll reschedule this and she'll explain everything. But there's just not proper service here. I'm sorry, I really am.
So if you will adjourn, and if I have to take another day off, can I add to that because of all this?
I can't give you wage loss.
Okay.
Where do you work?
I work for GD Cement Company.
Yeah, I know. Well,
And I took the day off today, hoping.
I understand.
I get your position, Judge, so.
Jennifer, I'm going to indicate you can Zoom. Do you know how to Zoom?
I don't really.
Get somebody to teach you. It's easy.
I got sisters.
A dummy like me, technology wise, can do that. You got-
Yeah, I get it.
Okay. So, yeah, you can do that if you want. All right.
Okay, do I speak to somebody else?
You'll go talk to the civil department.
Okay,
I wish you well.
thank you.
Sorry I couldn't accommodate you here.
Judge.
Good luck. Thanks.
Thank you.
What else do I have here? Good morning, Mr. Carmen. How are you?
How are you, sir?
Good, thanks.
Good.
Brown? Oh, wait a minute. I mean, Natalie Nicole Brown, 25F2589442. Your name?
Natalie Brown. Good morning, Your Honor. Michael A. Carter, B73824, on behalf of the defendant.
Why weren't you here?
I thought my court date was scheduled for the 8th, and I called that morning to find out that I had missed my court date. And also, my daughter was sick with hand, foot, and mouth the date I actually had my
Okay,
court
listen,
date.
I cannot sentence you now. I'm not going to do this. I read these reports, and I'm just sorry. We're going to have to reschedule it. I'll do that for you, but I just don't, I mean, I knew it was only 10 days ago or what have you, but I still want to go back and look at this file. Jennifer,
And Your Honor, if I may also, it was incumbent upon her attorney to remind her of her court date, and I failed to do so, so that one will be.
why? What do you mean? You guys got to remind everybody? What's going on in this society? I got lawyers not showing up. Now you're telling me you got a reminder? We gave her a written notice, right?
I'm not sure she went down and got it, Your Honor, so I should have better instructed.
I'll reschedule to September 4th at 8:30. You can go down the hall and get your notice, ma'am, okay? Good luck. Thank you. You got to show up on time. I'm going to expect you here at 8:30 that morning, all right? Thank you, Mr. Cartman. And by the way, I'll reinstate her bonds. Bond reinstated, okay?
Very good, Your Honor.
With
Thank you so
the
much.
same terms and conditions. Good luck, ma'am.
Thank you.
All right, do I have anybody? Where's this towering construction file? Do I have that? You have that down there?
I don't have anything.
I think those are time clocks.
Do we have any other file that I can call?
Judge, everything I have is for 10 and I don't have everybody checked in yet.
All right, well, I'm gonna get off the bench here for a couple of minutes and see what's gonna happen. Stay seated, sir. What's your name?
Robert Burton, sir.
What time are you up?
10 o'clock.
Okay.
There's nothing. I can bring them in.
Okay. On record.
Yes, John.
CKS Prime Investments LLC versus Affy Cobbs. 2502297. Good morning, gentlemen. Your name again?
Good morning. Oh, go ahead.
Hey, Todd Cobbs.
Good morning.
And Chris Royce, P49102 on behalf of plaintiff.
Is there any kind of resolution on this, Mr. Royce?
No, Your Honor, Mr. Cobbs and I spoke prior to the hearing, and I think we're going to be able to get it resolved. I've gotten his email. I sent my contact information, and I think that we will probably have this resolved within 30 days.
We'll adjourn the pretrial for 4 weeks with the hopes that you two will resolve this, okay? Give me a date, Jen, the other one you gave me.
The 22nd at 8:30?
No, didn't I do another one earlier?
Oh, the
4 weeks?
15th at 8:30?
I thought there was an earlier one.
Or you have the 8th.
Yeah, let's do the
That's a
8th.
little less than 4 weeks, but yeah.
Sorry.
Okay, the 8th at 8:30.
Okay, you guys, we'll adjourn the pretrial to September 8th at 8:30 with the hopes that you'll resolve it. If not, I'll just set a short discovery period and set it for trial, okay?
Thank you, Your Honor.
Have a good day, gentlemen. Thank you.
Yep.
What else?
Judge LV, NV, and Burton are ready?
Okay. Wait 1 second, sir. Sir, just wait 1 second till I call it, okay?
There's that one, Judge, LBND.
Just give me all of them.
Yes.
LVNV versus Robert Burton, 2501460.
Good morning, Your Honor. Elizabeth Romeri, P66, standing in for attorney of record on behalf of plaintiff LVNV.
Your name?
Robert Burton.
Did you file bankruptcy?
Yes, sir.
Do you have proof of that?
I have everything right here. I'm just waiting for everything to get finalized. I got certificates and everything, sir.
Did you give that to the civil department?
No, I have not yet.
Did you send it to the plaintiff's counsel?
No, I have not yet.
But your lawyer filed your bankruptcy.
Yes, sir. I'm filing it. I'm just going over everything right now.
Wait a
All
minute,
the
slow down.
paperwork that's
Slow
on
down.
there.
Has it physically been?
No, it has not.
Okay, I mean, I don't, I'm gonna adjourn it one last time for 2 weeks. If you haven't filed bankruptcy, I'm gonna set it for trial, okay? August 26th, Jennifer, at what time? 8:30. We're gonna adjourn the
Judge, yes, I'm sorry. Yes, that's correct.
August 26th at 8:30, okay?
Very well, thank you, Your Honor.
Think you'll have it filed then, right?
It should, yes, sir.
Okay, because I thought last time we were gonna have it filed by today.
Yes, I had all the paperwork.
All right, just make sure you get it filed. If you don't, then we'll just set it for trial, okay? Have a good day. Thank you. Thanks, counsel. April Langston versus Elena Concrete Services, 2501181R.
Judge, I've not had either party appear on this, and this was the one that we had a motion to consolidate on. And at the time, we gave them a new notice for the pretrial, and neither a party has appeared. I can call plaintiff or defendant's attorney.
Give me the rest of those. Yeah, do that, okay?
Okay.
TD Bank versus Kristen Gazdecki, 2502123.
Judge, they're still in a breakout room. I can get them to move out.
Give me the Bynum, Towering Construction versus Bynum.
Judge, I don't have that on the docket. Was that a motion? We got two that came off right at the end of the day yesterday.
I don't know. It's 2501334.
Oh, there was a stip in order to adjourn that just got filed with us. We've moved it to September 8th.
Tabitha, hold on. September 8th.
Yes, Judge.
Why? What did they need an adjournment of this for? Did
I
they say-
didn't look at, I'd have to pull up the stip.
So simple motion to set aside the fault. I don't know what to do. I'll let you call them. TD Bank versus Kristen Gazdecki, 2502123. Your name, ma'am?
Kristen Gazdecki.
Counsel?
Good morning, Your Honor. Seth Goldner on behalf of the Buckles office. I'm of counsel representing the plaintiff today. Good to see you.
Good morning, you too. Is there any resolution on this?
Well, Your Honor, we were we had a wonderful conversation from my point of view, a lot of information exchanged. I felt like we made a lot of good progress, and I was about to get to the part of the conversation where I tried to see if we could resolve. So let me just ask Ms. Gazdecki directly. Ms. Gazdecki, we did talk about potentially having you stipulate to a judgment and then work with the Buckles office on a payment plan afterwards, or another option that the court, Your Honor, I believe plaintiffs filed a motion for summary disposition. So I think we have two options.
Why don't I put you guys back in the breakout room? I dragged you out of there, I think. If you guys need to finish your conversation, I don't have a problem with that.
I'm fine with it. Kristen, do you want to talk for another minute?
No, there's nothing else to talk about.
Okay.
So ma'am, you don't stipulate, you don't wish to proceed with a judgment at this time and a payment plan?
Judge, if I can say something, I had filed a hardship with their office. They sent me a hardship form because I filed for disability. I have over 200 and 20 or 30 days left for determination. So I offered a payment plan and it was denied. They said they want either $4,900 up front for a one time, or they wanted like $500 or $600 a month for 2 years. That was from the previous attorney that represented this case 2 weeks ago that spoke to you. And she said they will not take less. I called the office yesterday. I offered like $50 a month. They said, no way. So
okay. Slow down. So there's two aspects to every lawsuit. One is, for lack of a better term, is the defendant liable for the amount of money claimed? And two is, at what rate are the payments going to be made? If there's no dispute as to the fact that you owe the amount set forth in their complaint, which is $6,026.31 plus their costs, you can stipulate to a judgment, and I can determine what the amount of the payments will be. I'll ask you questions. I'll swear you to an oath. Mr. Goldberg can ask you questions, and we can present a consent judgment for $6,026.31 plus any costs, and I can make the determination as to how much you can afford to pay. Does that seem reasonable?
yes.
So does Mr. Goldberg, how much do you have in costs? Do you want your costs?
Yes, Your Honor, and if I may, just to give you a little background, what I was discovering when I talked to the defendant was that she had, the Buckles office has a financial hardship review procedure, and she had just started the process of providing information. So normally we would hope to have that conversation earlier before the hearing, but the timeline didn't provide it. So she is in the process of verifying her hardship. I have no authority to accept any particular amount of a payment plan, but my practical suggestion would be as follows. One would be based on the answer that we do enter the judgment, either by stipulation or perhaps, pursuant to our motion next month, but that in the meantime, now that we're aware of the hardship and Ms. Gzdecki has started to provide some information, perhaps we can take her hardship into account ourselves and not have to take up the court's time with a motion for installment payments unless it's necessary. But Your Honor, I want to do what's efficient. I want to do what's right. I don't want to push Ms. Gzdecki at all. She is starting to do the procedures that the Buckles has. She's been a little frustrated by what's happened so far, meaning she just hasn't been able to get any concurrence to the kind of plan she's proposing. I don't know that it's unreasonable, but we have a procedure and due diligence we have to follow. So we could either, my thought would be enter the judgment today and work with Ms. Gzdecki and hope to come up with a payment plan, or kick the can until the defendant's motion and work with her in the meantime, or.
Working now, ma'am?
No.
How are you supporting yourself?
What I'm doing is my son has 2 toddlers and another one on the way, and I help his wife because she's a stay-at-home mom. So he doesn't directly pay me. He'll pay like my, phone bill, and he gave me a car to drive, pays the insurance. He gives me money for gas. I do live in Section 8 housing, so I do not have a rent payment, only $5. I do pay electric, which it's minimal. Those are and internet is $14 a month, and I receive food benefits.
Okay, so I don't care how we do it. It seems like it's in order for a judgment to be entered today. If you want me to decide on the installment payment order today, I'll do that, and I'll enter a separate order. If you want to deal with them on the hardship, that's fine. Whatever you want. But it doesn't make any sense to prolong the case if you owe the debt, is what I'm trying to tell you.
Yes, and that's what I agree. Why would we prolong it? Because I already agreed I owed it, and I asked for like a hardship payment plan, and they won't give it to me. So yes, if you could give me something that I could easily afford, I would love that because I want to make payments.
Any problem with that, Mr. Buckles?
Oh,
I'm sorry, Mr. Goldner.
Yeah, no, it's all right, Your Honor. Well, Your Honor, the Buckles office, as you know, is very well run, very procedurally oriented. I don't have the authority to say yes or no. I'm not going to, I would just ask the court to let us work out our own hardship procedure because but whatever the court wants.
This is what I'm going to do. What kind of costs do you have? Let's start with that.
Your Honor, I think it's about 137. Give me a moment and I'll recite the exact.
So they are entitled to those, ma'am. You owe $6,026.31.
Okay.
Yes, Your Honor. I'm sorry to interrupt. 135.20 in court costs, and the particulars are again 135.20. The particulars are $75 filing fee, $40.20 service fee, and a $20 motion fee.
So that's 6161.51, right?
That's exactly right. And in interest.
All right, now let's do this. Does he have your permission to sign your name to a proposed consent judgment indicating that you owe them $6,161.51? Let's start with.
Yes, sir.
So you're going to prepare that judgment and send it over, and she's just giving you permission to sign her name. Now, I suppose technically I should make you file a motion, but I'm going to waive your fees anyway based on what you've said. And there's no hardship or prejudice to them. So I'm going to swear you to an oath And I'm going to determine in a separate order how much you're going to pay on that, okay? So I'll ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
Yes.
All right. All right. What sources of income do you have?
I have zero. The only income that I have, like I said, well, from that it's a donation, but I sell clothes on like my stuff online just to make a little bit of money.
And how much are you asking to pay?
I was asking like 50 a month. I mean, I could possibly do 75, but that would be the absolute max at
Have
this
you applied for
time.
disability, ma'am?
Yes, I did.
Where is that pending? In other words, what stage is that is? Did you just apply? Did you apply 7 months ago, a year ago?
I applied in February. You have the file. I turned it into the court last week. It was a copy.
I believe you.
It was in February.
Slow down a second. Mr. Goldner, ask any questions of her that you would like.
Oh, well, Ms. Gazdecki, is all the information that you shared with me in the breakout room accurate?
Yes.
All right. Well, I'm satisfied, Your Honor. The only stipulation or the only condition that I would suggest, if the court would be willing, in whatever amount that the court wants to set for this payment plan is fine. We would just ask for a 6-month review opportunity.
Fair enough. Here's what I'm doing. I'm going to make it easy. I'm going to ask you to prepare an installment payment order that I've set up, not make clear that you're not consenting so you don't get in trouble. You're going to do a separate judgment in the amount of $6,161.51, then an order for installment payments that calls for her to pay $50 per month beginning September the 1st of 25. And then this order is subject to review on motion of either party on or after March 1st. Okay?
Okay.
Will you send that over to me too, Mr. Goldner?
I will, Your Honor, I will. I'm not the drafter, but I'm going to immediately report to the Buckles office. I'll immediately let my supervisors and the attorneys who would generate that know. And with a little luck, we'll get that e-file today.
Perfect. Thank you. Have a good day, Mr. Goldner. Ms. Gazdecki, do you have any more questions?
Do I come into the court to pay or can I pay online?
You're going to pay their office direct.
Oh, okay. Okay.
Do you want to tell them how to do that?
Oh, yeah. We'll put the instructions in the order.
Okay.
And then will I receive that in the mail?
Yes.
Okay. Okay. Sounds good. Thank you so much, both of you. Thank you.
Good luck, ma'am. Wish you well.
Okay. Thank you.
Very welcome. Your Honor,
Okay.
thank you for giving us the time today. I do appreciate it.
No problem. Have a great day.
Thank you, both of you.
All right. Take care. Bye-bye.
Thank you.
Bye. All right. JP Morgan versus Colin Snyder. 25-02676. Good morning.
Good morning, Your Honor. Elizabeth Riveri, standing in for attorney of record on behalf of plaintiff JP Morgan Chase.
Give me 1 second, please.
Of course.
What is your P number?
66192.
All right. Good morning, Ms. Law. Your appearance?
7, appearing on behalf of the
Wait a
defendant.
minute. I only caught the last couple words there.
Good morning, Attorney Brittany Law, P83917, appearing on behalf of the defendant.
All right. No resolution here, I presume.
Not as of yet, Your Honor. The parties did have an opportunity to speak. It's my understanding that the defendant continues to work with the debt consolidation company. Ms. Law has indicated that the company has reached out to plaintiff's firm with an offer. I don't have any notes or indication that an offer was made, so I've asked her to reach back out either to her client or the debt consolidation company to have them contact the plaintiff's firm with that offer so that we can continue discussions.
Okay. Witness list due September 15th. Discovery cutoff October 15th. you don't have to file a trial brief. If you choose to file, it has to be filed and exchanged not later than 7 days before the trial. No settlement conference, no ADR. All motions have to be filed and heard not later than 20 days before the trial date. Jennifer, give me a trial date in early November, mid-November. Same time as I said any of those other ones, if you would.
November 17th at 10:30.
November 17th at 10:30 will be the trial date, okay?
Very well. Thank you, Your Honor.
Anything
Your
else?
Honor.
Have a good
No.
day, you guys. Thank you. Okay, so this one has to be worked on. Did he come in to do his signing on record?
He has not been contacted me, Your Honor. I called him and I sent him a text.
Well, can you come over to Grosse Ile and see what's going on? Do we have the parties showing up on Langston versus Atlanta Concrete?
Judge, no, I spoke with Elena Concrete's attorney, and she did not have today on her books. I know we gave the notice to the plaintiffs when they were here. She was asking if we can adjourn it to the 26th at 10, just.
I'm gonna let you reschedule it, okay?
Okay.
Send it to both parties. Thank you. Do I have anything else this morning?
They do have an 11 o'clock arraignment with Mr. Bogart on your docket for a felony.
What case is that?
David.
Can I see it?
It's at 11 o'clock, supplementation first.
Yeah, this is important. I don't think he's answering. We need somebody to do a sign up record.
Did we set that or how'd that get set?
Judge, I'm not sure.
Good morning.
Good morning, sir. You're Juan Sanchez. And this is cause number 18-30854. Got a motion to revoke probation. I guess set for an announcement. Were y'all, before we go any further, were y'all able to work out getting everything discovery-wise, that anything that was an issue?
Yes, Your Honor, we've received discovery and I've reviewed it.
Okay, perfect. And so what is the announcement?
We are ready to proceed.
Okay, and so there's no agreement?
We haven't really discussed that. I don't think he's going to accept any revocation offer, Your Honor.
All right, so what we can do is just go through that motion, get pleas of true or not true, and then we would reset it for a hearing on sentencing, get a pre-sentence report update done. Does that sound like what we need to do?
I think so, Your Honor.
All right, let me get this.
Yes, Your Honor, he does want to stay. I just checked with him this morning again. He wants to stay on probation.
All right, so we'll go through that motion. Let me get it pulled up the right way. Mr. Sanchez, the best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Speak up, please.
Yes, Your Honor.
Thank you. And will he waive the formal reading of that motion?
Yes, Your Honor.
Let's see. All right, Mr. Sanchez, I have a motion to revoke your community supervision. Shows that you were placed on probation September 30th of 2019 for the offense of driving while intoxicated, a third-degree felony. That was an 8-year sentence in prison, but it was probated for 10 years. Is that correct? I need everyone to please hold it down. If you're talking to a DA, that's fine. Everyone else. Mr. Sanchez, is that correct? Okay. Thank you. Count one in this motion alleges that you violated your probation by committing the new offense of driving while intoxicated, third or more, April 15th of 2025 in Wharton County, Texas. And is that true or not true?
Yes, Honor.
That's true? Okay. Count two alleges that you failed to provide verification of having the auto ignition interlock system on your vehicle. Is that true or not true?
Yes.
It's true. And then count three alleges that you failed to never become intoxicated or under the influence of an intoxicating substance, and that you were intoxicated April 15th of 2025. Is that true or not true? It's true. Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? Okay. And did you plead true to those counts because they're all actually true? Okay. I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do that today. I'm going to reset your case so that the probation department can do an updated report and give me more information about what's been going on probation and all of that. And then we'll come back at a later date for sentencing. If there's anything that you think is important for me to know, get that information to Mr. Franklin, and he will present it to me on your behalf when we come back. Do you anticipate any witnesses or anything?
With a plea to true, Judge, I'll just wait and see what the report has to say.
Okay, sounds good. We'll reset it for sentencing. Thank you.
Thank you, Your Honor.
Oh, we need to get his fingerprint while he's here, please. Unagreed, yes, ma'am. Yes, thank you. Let's see, is Mr. LaGroppe here? LaGroppe? On Courtney Joseph? Courtney Joseph. Good morning, sir. Say, how do you pronounce it? LaGroppe or LaGroppe? LaGroppe. Okay. I was right the first time.
I recognize you were in here, I think.
I've been in this court.
We've been here for.
Yeah, it's been like 7 or 8 years since I've been here. This time it's not a family member though. That's fine.
Oh.
It's my brother. They dismissed.
I had to put up the
money to get it dismissed.
I feel like I remember some vague memory of that.
And I didn't know if you knew some of my cousins. See, my whole family's from Port Arthur.
Yeah. Oh, are they?
Yeah, they all went to TJ.
Oh, yeah.
My uncle, Leslie J.
My husband went to TJ.
He coached, he was principal and Bum Phillips was the coach.
Oh.
30 years, so I had 15 biological uncles.
Oh, wow. That's
Agents.
Okay, as soon as she's on the other side, they'll walk her down. As soon as they get her down, we'll take care of this. And this is just a bond hearing for the motion, right? All right. Oh, never mind. Come on back. Let's see. Pull this up. Oh, cool. All right, this is cause number 23 DCCR 0167. And are you Courtney Joseph? And so Ms. Joseph is on probation for assault on a peace officer. That probation started on December 11th of 2023. It was a 5-year deferred probation. A motion to revoke that probation has been filed with allegation of driving while intoxicated with a child passenger. I guess there must have been at least 3 of those passengers because there's 3 charges. Violation of committing the offense of resisting arrest. Allegedly left the county and was in Orange without permission. Out past court-ordered curfew. The new offenses alleged were at 10:17 p.m. in Orange, it looks like, yeah. And behind on fees. And Mr. LaGroppe has filed a motion asking that I set a bond. It is a deferred probation, so typically a bond would be set depending on certain circumstances So Mr. LaGroff, I will go ahead and let you want to call your client, or if you would, ma'am, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you.
And I'm just gonna question her about her financial circumstances.
That's fine.
Okay, how long have you lived in Jefferson County?
Since 22. August
Speak up some for me and for the court reporter, please.
August 2022.
Okay.
Where did you live before that?
In Orange, Texas.
How long did you live in Orange, Texas?
Almost 2 years with my grandmother
And where did you live before you lived in Orange, Texas?
in Port Arthur.
Port Arthur. How long did you live in Port Arthur?
For 3 years.
Let me ask you this, where were you born and raised?
Orange, Texas.
So you lived in the general area of Jefferson County, Orange, Texas, and Port Arthur since you were born, right?
Yes.
Okay. Have you ever moved out of state or anything like that?
No.
Okay. How many children do you have?
I have 5.
And where do they all live?
With me.
What type of work were you doing when you were on probation?
I was care provider.
Care provider. Explain to the judge what you mean by care provider.
I provided for an elderly man. I cook, clean, 3 hours, 3 hours a day, 5 days a week.
How much money were you making with that?
Just $8 an hour.
How much money approximately would you make a week?
How much it's worth? So like 140.
And so you make about $140 a week?
Yes.
So you would total about $600-700 a month?
Yeah.
Okay. Where do you and your children live?
On 8th Street.
Do you live with your family or do you live by yourself?
Me and my children, my mom just moved back in.
So your mother just moved back?
Yes.
Before the allegations that are alleged in the motion to revoke probation, who were you living with at that time?
Just me and my children.
Okay. You and your sister?
Me and my children.
You and your children. If you're only making $600 a month, how are you paying rent where you live?
I also get Social Security survivors. My children's father had passed in 2000.
And how much money do you get for the survivors?
$780.
$780 a month. Okay. And approximately how much money do you have right now in the bank? None? Okay. If the,
Speak up.
I get paid around the 15.
how much money will be coming in?
780.
And so, if the court were to set bond in a reasonable amount, okay, would you show up for your court appearances?
Yes.
Okay. You understand the allegations against you, right?
Yes.
Okay. And you're gonna have to appear in Orange County, correct? I mean, what's the county of Orange? I can't.
Orange. Mhm. It is.
I should know that. Orange County, so what was your bond set out in Orange County?
3.
3 what?
3,000.
Okay, 3,000. So, and did you post that bond?
Yes.
Okay. Have you had to show up for court yet for that yet?
No.
When is your next court appearance for that?
I have no idea. I was calling every Monday like I was supposed to, and then when this one came in, I turned myself in.
Okay. And you did once you found out, you talked to your probation officer, they told you they were gonna file a motion to revoke, right?
Yes.
And you reached out to me, correct?
Yes.
And then you and they had to schedule a meeting for, I think it was July 31st.
The 31st, 49 o'clock.
And you turned yourself in the day before?
Yes.
Correct. Okay. And you knew you were gonna be arrested if you came?
I'm pretty sure.
Okay, I pass on.
Any
I
questions?
have no other questions for purposes of this hearing, Your Honor.
All right, any other witnesses?
No.
Mr. Nichols, what's the state's position on
I
this?
don't mind the court setting a reasonable bond in this case, Your Honor. I just want there to be sufficient conditions in place to keep her from driving, and she needs to, I think, have an alcohol monitor of some sort. I'll note, all these violations except for the fees and stuff, all are one incident. There's not a history of testing positive or anything like that. So whatever the court sets is fine, as long as we have those restrictions that we need.
Okay.
Can I elaborate?
Yes, sir, please.
Very minor amount. Her mistake was she went to a family gathering. That's why she left the county. That's why she left to go to a family gathering with all her children. That's wherein the rub lies. bad judgment.
Very. Especially while you're on probation for a second-degree felony. So what I'm going to do is grant the motion. I'm going to, is there an order? I'm going to,
I'll follow.
okay. Let me look at one thing real quick. Original bonds. I'm gonna set your bond at $20,000. A condition of that bond, if you make it, will be that you will be required to wear a SCRAM device. And that is a monitor that you wear on your body at all times that will alert if any alcohol is consumed at all. Obviously, you will be ordered to remain in Jefferson County, Texas. Just like before, if you leave Jefferson County for any reason without permission, your bond, we're not gonna be talking about a bond again. You'll just be sitting in jail waiting on all of this. Do you understand? If you test positive for alcohol, then you're gonna end up right back in here. Do you understand that? Anything else?
I think that's sufficient.
All right, well, if, we'll reset it for a regular announcement and see where we get at that point, all right?
I'll try.
Okay, thank you, sir.
Orders.
Thank you.
You can just email it.
Mr. LeGros, if you want to just email the order.
Thank you. That was so very nice.
Good morning, Your Honor.
Good morning. How are you?
Well, yesterday I spent all day in Houston with doctors, so I'm glad to be here.
We're glad you're here.
But, you know, as I've said before, getting old is not for young people.
Good morning. Are you Ronald Spites?
Yes,
And Mr. Spites is charged with the offense of manslaughter in cause number 25 DCCR 0920. Mr. Macon has filed a motion asking me.
No, he was arrested for murder and indicted him for manslaughter.
Potentially knowingly causing the death of an individual.
Let me look at the indictment. It shows. I don't know why the heading
Heading says manslaughter, but the language.
did then and there
knowingly, not
intentionally
recklessly.
and knowingly cause the death of an individual, namely Rowan Williams, by striking him with an automobile. So at least on the indictment language, that would be murder. I know it's not, the headings are not sometimes important, but I think that needs to be adjusted and changed, especially if that is what is in, that's what's in Odyssey. So that's showing up on everything with the wrong stuff. So that needs to be amended if you can. Take care of that later. So based on that, it looks like the offense is actually the first-degree felony offense of murder, Mr. Spites. And Mr. Macon has filed a motion asking that I reduce your bond. Did I print? No, I'm printing it now, the PC. Bond is currently set. Sorry, I've got too many things I'm thinking about trying to do right now.
It's $800,000.
Thank you. Currently set at 800,000. Mr. Macon, do you wish to call your client?
Yes, Your Honor.
Sir, if you'll please raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Macon.
Now, what's your name?
Ronald J. Spikes.
And Mr. Spikes, you're the person charged with the offense. Okay?
Yes, sir.
Do you have enough money, you or your family, to post a $800,000 bond?
No, sir.
Okay. Now, before you were arrested, I mean, in the past, you were in lots of trouble, right?
Yes, sir.
And you've got some priors, but in the last 10 years, have you been in any trouble?
No, sir, I have not been in no trouble.
Okay, and you have your wife living in this area?
Yes, I have my
And-
wife, my family, everything.
Okay, and your family, and you have a job, were you able to make bond?
Yes, sir.
And that's with your father-in-law, Mr. Gonzalez, correct?
Yes, sir. Yes, sir.
And that's at 365 Scrap?
Yeah, yes, sir.
Okay, and did you also work for Zachary as a heavy equipment
Yes, sir,
operator?
I do.
So you've always been working and all?
Yes, I am,
Do you
sir.
have any assets whatsoever? Real property, coin collections,
No,
anything
sir.
like that? Then you're asking the court to set some reasonable bond so you could get out and go to work?
Yes, sir.
Mr. Smith, any questions? All right, any other witnesses?
No.
Mr. Smith, what is the state's position?
Judge, he does have a prior from 1998, where he sentenced 4 years GEC. So whatever if it's murder, he would be 15 to life at least. And if it's manslaughter, it's 5 to life. State court is reasonable for us.
Mr. Macon?
Your Honor, we think that $800,000 bond is excessive and would ask that it be lowered.
I am taking judicial notice of the court's file, which includes the probable cause affidavit, as well as there was a letter of support that was sent by Mr. Macon from a Rocky Johnson. Were you able to review that, Mr. Smith? I think it was emailed.
I believe it is.
Okay. Let me take a look at this real quick. And the prior was from when? 90?
98. November 16th.
Okay. Speak up, please.
It was from November 16th of 1998 for a 4-year sentence.
All right, 2, possession of controlled substance, same date. Got it. Okay. What I'm going to do is I am going to grant the motion for a bond reduction. I'm going to reduce the bond to $500,000. Sir? Did you want to say that again louder? You did say something.
Well, I didn't say nothing to it.
I'm going to reduce the bond to $500,000. A condition of that bond would be, if you make it, that you are on house arrest and required to wear a GPS monitoring device at all times. And we will get the case set for an announcement as quickly as possible. All right, sir? That's what it's set at right now, all right? You can go back with the bailiff. What?
I'll be back.
Ms. Perazzo, you have LaCaven Jenkins. Good morning. Is he pleading to the indictment as it is, or is there any?
It's as is.
Thank you.
I think Mr.
Phillips said that the discovery exhibit for one of those is being sent by Sarah since I didn't have it. Oh, okay, thank you. Thank you, Mr. Smith. Sorry. All right, are you LaCaven Jenkins?
Yes, ma'am.
And Ms. Perazzo, will your client waive the formal reading of the indictment in each case? Mr. Jenkins, in cause number 24, DCCR 1026, you're charged with the first-degree felony offense of aggravated robbery, and that is from March 3rd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then, in cause number 24, DCCR 1027, you're charged with the third-degree felony offense of fraudulent use or possession of identifying information from March 12th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? Answer out loud for me, thank you. And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents in each of those cases that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Perazzo?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Jenkins is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 24, DCCR 1026, find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Let's see, is there a, I am making an affirmative finding of a deadly weapon in that case. And then in cause number 24, DCCR 1027, also find sufficient evidence to find you guilty, and at this time find you guilty of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Perazzo. All right, good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Perazzo. Mr. Wilkerson, you've got Larry Fletcher. Looks like that's also a bond hearing.
Absolutely, Your Honor. And Larry Fletcher, Your Honor, we have a number of witnesses here.
All right, give me just a minute then.
Yes, Your Honor.
All 3 of yours are bond hearings?
Yes.
Okay, give me just a minute then. Huh? That's okay. Mr. Rennick, you've got Tyron let's get Tyron Henderson. The sentencing. Mr. Smith, this is yours on Tyron Henderson. I'm good. Good morning. All right, sir, you are Tyron Henderson. And Mr. Henderson was previously in court. We've got 3 MTRPs and a new case, and he entered pleas of guilty, or a plea of guilty in that new case, and pleas of true to counts 1 through 6 in each of those motion to revoke probation cases. I've received a pre-sentence report, updated. Wait, is there a 5th one? Or just 4?
There's 4 cases. 3 MTRPs and then.
That's right, something was just printed twice. Has everyone had an opportunity to review the pre-sentence report?
Yes, Your Honor. Yes, Judge.
Are there any additions or corrections?
Not from the staff.
Not from the defense.
So, I'm a little, well, probably a little more than a little concerned about your ability to be successful if I put you on another probation. Because you were on probation for 2 cases, an evading and an unauthorized use of a vehicle from 2021. Then you pick up a felony theft in 2023, keep you on probation, add a probation on that case. So now you've got another felony while you're on all of these probations. And you've already been to ISF. I just need some help here. And Ms. Joseph is here. Ms. Joseph, what's your thoughts?
I believe that Mr. Henderson can satisfactorily complete his probation terms, even with the addition of another term. Mr. Henderson, from the start, and I had frank conversation with him about his current situation as well as the subsequent offense. He understands the seriousness of it, the unnecessariness of this event, and he offered no excuses, which is refreshing. When I notified him of the warrant, he did not hesitate, and he turned himself in. When I spoke with him at the correctional facility, he stated that he would accept whatever the consequences were, or would be.
Well, and another thing, Mr. Henderson, which is a bit of a breath of fresh air around here, is you have absolutely no jail reports. And with the group of young people your age out there, that is pretty amazing because they're acting like fools, aren't they?
He's been in actually for 120 days too, Judge, so it's not just a short stint in jail.
So the recommendation is ISF again, which I'm not opposed to. I'm sorry?
A state jail sanction for 180.
Okay, that's not what it says on here.
Well, that was my recommendation.
Is there an issue with misuse of drugs?
No, it's cognitive.
Safety's.
I didn't recommend ISF. I recommended 180-day state jail.
Just 180 days
Yes,
upfront
that's-
time.
He's already been to ISF.
I
So
know.
I don't know why we would repeat that, but that's why I recommend
Same. Okay.
state jail.
Go get a feel for what it's like somewhere other than our
Yes,
jail.
yes. And we discussed that. I told him that's my recommendation, and he was willing to accept it.
All right. What do you think, Mr. Henderson? Do you have anything to say?
Judge, can I just say one thing briefly?
Mm-hmm.
He has been in for 120 days. He's had no write-ups. To his credit, every time I've met with him, he's accepted responsibility. He knows this is not a second chance, but a third and fourth chance that the court's giving him.
It's
He's
the
not
last
cynic-
chance.
Yeah.
That's what it
He's
is.
not a sinister young man. He knows that he's made some really foolish mistakes, and this last thing was him doing wheelies on a dirt bike. But I do think that he is someone that can be successful in probation. I think that he realizes too that this is not the path he wants to go down. And with every report, everything he said, he's accepting responsibility.
Yeah.
He knows he's messed up. And I do think he's somebody that, Judge, I really do think we're not gonna see him again.
So, Mr. Henderson, I want you to understand, if I go along with this today and you're back in here, I'm going to see all of this and I'm going to wonder what I was thinking today. And that's not going to be good because you're already you will be agreeing today to a certain amount of time in prison. And so we're not gonna come in here and negotiate. You mess up again, you're gonna be in here getting all the sentences that you're getting. Do you understand? Do you understand?
Yes, ma'am.
Okay. So what is the agreement is just to continue those probations?
Well, actually, the agreement was for ISF cognitive training.
Okay.
I realized he'd already been.
Yeah. So we've got 2 deferreds on those 21 cases in 5 years. Okay. In cause number 25 DCCR 0520, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. I'm going to sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections, but probate that, place you on probation for 10 years. That's what your agreement is. I am going to order a $250 fine in that case. And I am going to order that you serve 180 days upfront time. And there's not going to be credit for the time you've sat, because I want you to see what it feels like to sit somewhere other than Jefferson County Jail. All right? And cause number 21-38934, find that you entered your pleas of true, freely, and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do so. I'm going to continue you on probation in that case. In cause number 22-39131, also find that you entered your pleas of true, freely, and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do so. I'm going to continue you on probation in that case as well. And then finally, in cause number 23 DCCR 0899, find that you entered those pleas of true, freely, and voluntarily. Find sufficient evidence to revoke your probation, but I'm not going to do so in that case either. I am going to continue that probation. Cause number 21-38934, that's the evading arrest or detention with the use of a vehicle. So that's that first evading. I am going to, I'm continuing your probation, but I am going to extend it by 2 years. All right, so that's now a 7-year probation instead of a 5. Make sure to make that note. And then the other ones, I'm going to leave that other one. Okay. All right. So I'm going to hand you the trial court certifications in each of these cases, Mr. Smith, if you don't mind. This shows these were agreements that I followed, and so you waived your right to appeal. This new case, I want to make sure again that we're very clear that if you violate any condition of probation from this point forward, you are looking at a 10-year sentence in the first evading, 2 years state jail in the first unauthorized use, 2 years state jail in the theft, and 10 years that you disagree to in this case. Do you understand? So it's very important that you do everything. It sounds like Ms. Joseph believes in you and that you can do what you're in. You've showed that you can follow the rules in jail and for some time out of jail, but you've got to follow the rules all the time or you're going to end up in prison, and nobody wants that. All right. So take advantage of this situation. When you get out of doing your upfront time, go straight to probation, follow all of those rules, and hopefully we won't see each other here again. All right. Good luck to you, and go back with the bailiff.
Are we not doing state jail upfront time, just the regular?
State jail upfront time. Yes, ma'am. Sorry. Okay, we have Deshaun Robertson with Mr. Wilkerson.
He stepped out.
Okay, I'll hold that then. Let's see, Mr. Mr. Macon, you didn't have anything else on the docket? Okay. Mr. Lewis, you have Christopher Falk. Christopher Falk. Good morning. Good morning, how are you? Good morning, are you Christopher Falk? And this is cause number 24, DCCR 1891. I'm going to take judicial notice of the court's file. Mr. Falk was examined for competency to stand trial by Dr. Rapon. I don't know if we've done this yet in court. We did already, so I did already make that finding that Mr. Falk is competent based on that report. Is there any other evidence with regard to competency?
No, not from the judge.
Not from the state judge.
All right, will he waive the formal reading of the indictment?
He does, yes.
And we're going on count one only? Third degree? Okay.
Second count paragraph.
All right, thank you. All right, Mr. Falk, in cause number 24, DCCR 1891, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of assault on a public servant, and that is from August 19th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? See, state tenders number 1.
No objection, Judge.
It's admitted. Mr. Falk, I'm going to find that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent, you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of assault on a public servant, third-degree felony. Sentence you to, in accordance with your agreement, to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. See, Mr. Lewis, you have Kevin Tran. It says it's locked. Thank you, and bless you too. I know. All right, are you Kevin Tran? And Mr. Tran, in clause number 2137560, 2138780, 25 DCCR 0422, 25 DCCR 0423, 25 DCCR 0424. I'm going to take judicial notice of the files in all of those cases. Looks like the first two cases, he's on probation, and then we've got new offenses as well. Mr. Tran was evaluated for competency to stand trial by Dr. Grapan. I received that report dated July 21st of 2025. The finding in that report is that Mr. Tran is currently not competent to stand trial and that inpatient restoration would be called for. Is there any other evidence with regard to competency?
No, Your Honor.
All right, then based on that report at this time, I am going to find that Mr. Tran is not competent to stand trial, find that inpatient competency restoration is required, and order that he be sent to the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility, and then we'll await a report. Mr. Tran, we're going to try to get you some help so that you can understand everything that's going on, and then we'll get you back in court as soon as we can. You can go back with the bailiff. And then you've got a Michael White.
Yes, ma'am.
Mr. Let's see. He's already been and come, now he's back.
He's back, but he's not competent. He's still, they don't believe he'd be able to be restored. He's going to be able to be restored.
Okay. So,
You guys have extra insurance, that's right.
all right, you're Michael White. And this is cause number 24, DCCR 0782. And Mr. White was previously found not competent to stand trial, sent to the Dunn Behavioral Science Center, and we received a report from them dated April 4th of 2025. That report is from Samantha Guzman, and the opinion in that is that he is still not competent to stand trial, with the finding that outpatient competency restoration could potentially be something that would work for Mr. White. The problem with that is that we don't have an outpatient competency restoration program. And so, and that he's not likely to achieve competency. So I don't know exactly where that leaves us. Mr. Smith, what's the?
Judge, I believe his mother lives in Florida. She's willing to take custody of him. And I believe they have a program that is along the lines of this with outpatient competency restoration.
Yeah. Would we do that through a civil, or would it be a dismissal?
That was the question I had on you. We're willing to do whatever it takes to get him there.
And Judge, if I may, I've been talking with his mother. She's been in contact with the probation department there, just trying to get familiar with what kind of programs they have. They have a program there called the Gateway Program that works with their mental health department. That's basically similar, goes along parallels to what this would be. And the only issue that they've been having to try to get information on Mike is, from my understanding, they can't do the interstate compact without it having an out date or anything from when they would be getting out to leave to go down there.
But I can't, is this a motion or is this a new case?
It's a motion, because he was sent back from ISF, Judge.
Yep.
Okay.
He was sentenced to ISF as a term and condition of the probation term.
Mm-hmm.
He got to ISF and then started to regress. Right.
So I can, without pleas of true or not true, really, I think on that motion, I think we can just order that he live in a certain place, which would be with her, that he participate in those programs, and then the probation could transfer to that, correct? I mean, we can't do obviously any kind of pleas on anything,
No,
so
I
it would
agree.
require a dismissal of the motion to revoke.
I don't know, do we actually have a motion filed? I believe we just had this set for hearing because he was returned from ISL.
Gotcha, okay, so then we just need probation to do the, I don't know if you would necessarily take an administrative hearing or just send in me the, order to sign, ordering the Gateway program through, and if you can get the county and the address of it, where his mom lives, and
I
get
got
all
her
of that.
address and that information this morning, so I
And get all that to probation, does that sound like something we can do? Okay, well, let's do that then, we'll just, not go forward with anything, motions here, let's just, whatever conditions you need to add with regard to him being able to go there, and then we can kind of figure out when that's gonna happen so that they can get transportation. So if you'll work with probation, y'all get all that worked out,
Okay,
okay?
no problem.
All right, we're gonna get it where you can go live with your mom in Florida, okay? But you still have to follow the rules. Nope. I don't know if that's a good thing or a bad thing.
He's gonna give me life.
He's like, oh, no, not my mom. Don't make me go to my mom. Let's see, Ms. Holmes, you have Jamel Caddy. She must be in the back. Let's see, Mr. Parker, how about Alfredo Gayton?
You have that, Judge.
Alfredo Gayton? We have so many hearings this morning. Morning. Y'all marked second degree.
We're going to proceed on at least one of the priors to the court's permission. It is not something, there are additional priors that would enhance him that are not required under law, if that makes sense. Jurisdictionally, they're not required, but.
Let's see, so it looks like there's two, the first two are, well, we've got to,
So he received 5 years TDC on the 93 case and then 90 days on the 98 case. And then my position is that at least that 2004 or the 2009, whichever the court would like to recite, would enhance him from the third to the second.
so he'll plead on all, let's say, except for that last one, because that would actually enhance it again. All right, so you'll waive the March 3rd, 2009. We won't go on that, but everything else. Does that make sense to you too, Mr.
Yes, ma'am.
Parker? All right, sir, are you Alfredo Gayton?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
He will, Your Honor. I give you.
Mhm.
Okay.
I think so.
Yeah,
I think I already
did.
signed it
I did.
and
Okay.
handed it over. Give me just a second to get this pulled up. Mr. Gayton, in cause number 25 DCCR 0184, you're charged with the third-degree felony offense of driving while intoxicated, third or more, and that's for March 30th of 2024. The indictment alleges you were previously convicted of driving while intoxicated September 28th of 1993 in Harris County, Texas, and then after that, and then on July 9th of 1998, convicted of driving while intoxicated in San Patricio County, Texas. And then after that, you were convicted on July 28th of 2004, again in Harris County, of driving while intoxicated. And how do you plead to that charge?
Guilty,
And are those prior convictions true?
yes,
Did you enter your plea of guilty and true freely and voluntarily?
yes, ma'am.
And because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a cap of 14 years in the institutional division of the Texas Department of Corrections. I want to make sure you understand you have an absolute right to have a jury come in and determine two things. You could have that jury decide if you're guilty or not, and then you could leave your punishment up to that jury if they found you guilty. If we go forward this way, you're waiving that right, and you're leaving your punishment up to me. And as long as I don't give you more than 14 years, then you're waiving any right to appeal. Do you understand? Also, do you understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Gayton is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to restate your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Parker, and he'll present it to me on your behalf when we come back. All right, you can go back with the bailiff. Thank you. Sean Harley, Mr. Parker. Huh? Okay.
So I wouldn't be surprised if he changed his mind. He said he wanted to change his mind, but then he got to change it. He takes it back.
Good morning. Are you Sean Harley?
Yes, Your Honor.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
You will, Your Honor.
Mr. Harley, in cause number 24-2148, you're charged with the state jail felony offense of criminal mischief, and that's from August 28th of 2024. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
And then in cause number 25 DCCR 0739, you're charged with a third-degree felony offense of harassment of a public servant. That's from August 28th of 2024. And how do you plead to that charge?
Guilty, Your Honor.
Again, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And because you did what they've charged you with?
Yes, Your Honor.
In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Harley is not competent?
No, Your Honor.
All right, Mr. Harley, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. And cause number 24, DCCR 2148, find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of criminal mischief. Sentence you in accordance with your agreement to a term of 1 year in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 0739, also find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of harassment of a public servant. Sentence you in accordance with that agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I've handed you the trial court certification in each case that shows these were agreements and that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Kashawn Pugh, Mr. Parker.
The last guy I thought, they're running CC, what cases in jail, in probation, he didn't take probation.
Because what?
Because he thought that his time that he's serving in jail right now would run CC, that it would eat up his case. He only has 2 months in this case. I mean, I explained to him for 45 minutes.
Pugh?
Judge, on this, we have a plea in the new case and then an offer on the probation if the court would accept it based on the reasoning that he has no current felony history.
Okay. I'll probably do an, I might do it today.
The motion is on the state jail.
Oh,
The
I
new
see.
case is the-
Okay, and it's not to
It's for
continue.
today.
Okay. All right, are you Kashawn Pugh? And Mr. Parker, will your client waive the formal reading of the motion and the indictment?
You will, Judge.
Mr. Pugh, in cause number 23, DCCR 1531, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from June 18th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In that case, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? And do you fully understand them? Answer out loud, please. Thank you. The court reporter has to take everything down. And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. And Mr. Pugh, you are a U.S. citizen, correct? Is there any evidence that Mr. Pugh is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Let's see. And then in cause number 19, 33356, give me just a second. Yeah.
Kim just realized we had Adams. I don't know if you need it or not since they came up with something.
No, not since they came up with
Okay, I
something.
thought-
Thank you, though.
Yes, ma'am.
Actually, let me see that again. No. What I'm looking at right now is your jail incident reports. You don't like being told what to do out there, do you?
That's not the issue. People come to work with problems of their own.
Okay, so it's the correctional officer's faults that you don't follow the
All
rules?
time when I walked across the dorm and gave a guy his bowl, I did that. I was working out in the bathroom, I did that.
Okay.
Miss Painter, she called me on my name multiple times and I asked her to identify herself. The other things that she wrote in there about me were not true. I had another officer read it to me, so I know what it says.
Okay. There's only one.
Mr. Washington wrote me up, and that was a lie. That's why I got moved to orange, because I actually was in blue at first. And the lieutenants don't even know why I was in there. I was actually in dorm, placed in dorm under, so to say, Stroder's advisor, but Stroder never wrote me up, so I don't even have a write-up for that. They don't have that in there either.
Okay. I mean, it sounds like you're saying you did most of what they're saying you did
No, I
wrong
didn't do
anyway.
most of what they're saying at all. Most of those write-ups, Washington and Painter, and I think another lady, I didn't do the other things that she wrote up. Butte wrote me up for some other things, and I told her that I can't do her job for her. She wanted me to point somebody out, and that was she just wrote me up on it. So.
Okay. So Washington didn't tell you to stop talking,
No,
and
he
you
didn't.
responded by saying, quote, "Officer, you telling me we can't talk in the bunk area? You tripping." You didn't say that?
I did not. That man did not tell me nothing that whole day. He didn't. And when I asked him if I had a write-up, he told me no. And then he actually wrote me up 2 days after they moved me from blue to orange. That wasn't even the same day.
And you didn't go to the restroom and wash your clothes in the sink, and he
No,
told
ma'am,
you
I
not to
did
do that?
I did not do none of that.
You just
I
made
asked
all
him-
that up?
Man, I swear, I asked the lieutenant to check the cameras and see if that's what I did, and she didn't want to do it. So that write-up was just for nothing. When I asked him if he wrote me up because they told me that I had a move card, I said, "Why am I moving from blue to orange?" He said, "I don't know." And I was like, "Well, did you write me up for something?" He said, "No, I didn't write you up. The lieutenant called and said that you had a move card, that they was placing me in my right because I have a felony case that I'm supposed to be in orange." And when I came in at first, I told them that I was supposed to be in orange, but they put me in blue and told me that they were.
Sounds like you know their job better than them, huh? You're just out there telling them what to do and where you're supposed to be and all that kind of stuff. See, here's the thing. I don't have to accept any agreements in here. And I know word out there, it's got to be getting around that I'm not accepting agreements. I'm putting people back in jail because of these incident reports. Because these people are just trying to go to work and do their job, and they don't need you or anybody else telling them how to do their job, where you're supposed to be. You're supposed to be where they tell you to be. You're supposed to wear what they tell you to wear. That's part of being in jail. You don't get to make your own rules. Stop breaking the law and you can do what you want and wear what you want when you're out. Does that make sense?
It does make sense.
All right, so in clause number 19-33356, I have a motion to revoke your unadjudicated probation. This one shows that you're placed on probation December 7th of 2020 for unauthorized use of a motor vehicle. That was a 2-year probation. Looks like it was extended at least once. Is that correct?
Yes, ma'am.
Okay.
It looks like this motion was filed in 23, so that needs to be worked a little bit. He's just been at large on it since.
Okay. It alleges that you violated your probation. Count 1 alleges that you committed the new offense of evading arrest, June 18th of 2023. And is that true or not true? True or not true? True. Count 2 alleges that you failed to report as directed to the probation department April 10th, May 22nd, and June 12th of 2023. And is that true or not true?
True.
Count 3 alleges that you didn't work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
I'm sorry?
Not true.
Okay. Count 4 alleges that you failed to immediately report to the probation officer a change of address and your arrest. Is that true or not true?
Not true.
Count 5 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
Count 6 alleges that you failed to provide verification of participating in the education program for your GED. And is that true or not true? Count 7 alleges that you failed to provide verification of paying court-ordered child support. Is that true or not true?
Not true.
Count 8 alleges that you're behind in your court-assessed fees as of June 26, 2023, in the amount of $2,361. And is that true or not true?
That's true.
So he was at large since 2023? Is that what this, I would assume from this? Since there's,
That's what I would assume, Judge, just from the file stamps and the fact that his last admin was in 23 as well.
so did you just stop going to probation back in 23?
Yes, ma'am.
That's after he got arrested on the new case, apparently. But that's what it appears, Judge.
No, that was before I got arrested.
Yeah, the new case is from March of 2024, so you had already stopped going for
Yes,
almost a
ma'am.
year.
Because she was planning to violate me for
This
any
is-
reason, I don't know why.
This is June 18th of 23, I thought.
I'm sorry, I'm looking at the wrong thing. Hold on. Looking at the wrong thing.
He was supposed to be.
2023, June 18th, yeah. Stopped reporting in April. New offense in June. I don't know if I like it or not. Guess it really doesn't matter a whole lot just because it's gonna, I already gave them the 3 on the other one.
We can rediscuss it, Judge, and raise the time.
I'll do it. All right, so I'm going to find that you entered your pleas of true to counts 1, 2. Well, let me go through this first. I have also in this case, on the motion to revoke case, some documents here on the computer that have your signature on them. Did you also go over these with Mr. Parker? And you fully understand them?
Yes, ma'am.
Again, you understand if I follow this agreement that you'll be waiving or giving up any right to appeal.
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. All right, I'm going to find that you entered your pleas of true to counts 1, 2, 5, 6, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a motor vehicle. Sentence you in accordance with your agreement to a term of 1 year in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certifications in each of these cases that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, you can go back with the bailiff. Daniel Turner, Mr. Parker,
These guys try to talk their stuff out of a plea.
this one?
No.
Oh, I know.
At first,
Yeah.
at first he wasn't a plea. This guy.
He's pretty lucky he did.
How are you?
Good morning.
Good morning.
Good morning. Are you Daniel Turner? And will your client waive the formal reading of the motion?
He will, Judge.
Mr. Turner, in clause number 22-41012, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 10th of 2023, and that was for the state jail felony offense of unauthorized use of a vehicle, and that was a 3-year deferred probation. Is that correct?
Yes.
The motion alleges in count 1 that you failed to comply with the orders of the McLennan County Probation Department by not making consistent payments towards your financial obligations. Is that true or not true?
That's true.
Count 2 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
It's true.
Count 3 alleges that you failed to report to the Jefferson County Probation Department by mail or reporting online for the months of May, August, September, October, November, and December of 2023. And then January,
The whole year of 24.
yes, the whole year of 2024, and then January, February, March, and April of 2025. Is that true or not true? Okay.
And Your Honor, if we could just skip to 6, I think in light of our agreement.
Y'all wrote 1, 2, 3, and 4.
I meant 6.
You meant 6?
Yes, Your Honor.
Okay.
Sorry.
Mind if I make that
No
change?
objection.
No objection, Your Honor.
And then the state's elected to go forward just with 1, 2, 3, and 6. Count 6 alleges that you failed to provide verification of attending and complying with all of the treatments through the Heart of Texas Behavioral Network. And is that true or not true? Did you enter your pleas of true to counts 1, 2, 3, and 6 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
And do you fully understand them?
Fortunately.
And do you understand if I follow the agreement that you made with the district attorney, you'll be waiving or giving up any right to appeal?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Turner is not competent?
Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 3, and 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty, and at this time, find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification. That shows that this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right? Good luck to you, sir.
No.
Did you have a question?
I thought I was
1244. You got a 1244, so you're going to serve your time. You got a felony conviction, but you're serving your sentence in the jail.
So I'm gonna stay where I'm at.
Yes. Yep.
Judge, I pivoted to that other charge just to make sure the mental health was addressed too, because that's an issue on it.
That's what it looks like. Thank you. See, who's here? Mr. Wilkerson's here. All right, is Miss Holmes in the back working, I guess? Maybe Mr. Wilkerson, let's take care of Larry Fletcher.
You wanna set the bench, John?
How many witnesses? How many?
4 or 5.
Judge, if it would help, the state is amenable to making certain stipulations if it will cut down the time.
Sure.
And witnesses in this case.
Sir, are you Larry Fletcher?
Yes, ma'am.
And so, Mr. Fletcher is on probation and cause number 21-37809 for the offense of possession of a controlled substance, a second-degree felony. That probation is from October of 2021. It was a 5-year deferred probation. And then it looks like we have 2 new offenses that have been indicted in cause number 25, DCCR 0838, an aggravated assault with a deadly weapon, and 25 DCCR 0839, a manslaughter charge. Mr. Wilkerson has filed a motion asking that I set a bond in the motion to revoke case.
Yes,
Is there,
Mr. Fletcher.
hold on, is there any motions in the other 2, or we're just talking about the,
I believe the state filed a motion seeking to actually increase the defendant's bond.
in which
Your
case?
Your Honor, I filed in both cases. In the MQRP, you filed a reply to the defense counsel's motion to set a bond. And then in the other 2 cases, the state, the aggravated assault and the manslaughter case, the state has filed motions to increase those.
Let me get that all pulled up real quick and then we'll get started. Hold on. I'm printing. I needed to see all that. I just printed the response and it's okay. We'll get it.
It's all your fault.
That's all my fault. It always is. In my mind.
I'm used to taking.
In my mind, it's always my fault.
Are the PCs, I guess, or would be the same in
For
the manslaughter and the ag assault? So I'm just
Assault, they
printing.
came out of the same transaction.
Okay.
Occurrence, Judge.
Give me just a second.
Yes,
Hold
sure.
on. All right. So there's no bond currently set in the motion to revoke. The bonds in the 2 new cases have been set at $50,000 each. So I've got a motion to set a bond in the revocation, and I've got a motion from the state to increase the bond and or modify conditions in the 2 new offenses, correct?
Yes, Your
Okay. With regard to well, I guess, Mr. Coleman, you mentioned that you would be willing to stipulate to some things before we get started with witness.
I suspect Mr. Wilkerson will call these witnesses to talk about the length of the residency and the ties in the community, those kind of perfunctory things. If it will shorten this proceeding, I'm willing to stipulate to those if Mr. Wilkerson.
I mean, it to some degree, that is some of it, but obviously there are more intricacies involved, including the nature of the family, the length of work, things of that nature that I think all need to be put into play here.
And I don't mind hearing the evidence. I don't want to hear the same thing. They're here, and I appreciate they're here, and I'll take notice of that. But what I don't need is to hear from all of the witnesses the same thing about work and living and all that. So if you want to call one or two that have that information,
absolutely,
that would be great.
Yes.
I just don't want it to be the same thing, and I'll take notice that they're here and that they would all say typically the same thing, as if that's what it is.
He's on bond on 2 of those cases. I'm calling the bondsman right now.
Yes, he is.
He's already on bond. They filed a motion to increase the bond.
That's correct. So he, obviously this very tragic accident occurred one evening. There is no allegation of any substance use on the part of Mr. Fletcher contributing to the accident that involved the death of one of the victims and the severe injuries to the other. There is some, I guess the state's theory seems to be on the manslaughter, that he was reckless in his driving on that evening, thereby causing the death of another in the course of that reckless behavior while driving, which then makes it a stretch when the state then moves on to an aggravated assault charge for the second occupant of the vehicle, because of course if there were the intent and knowing element present there of course would have been a murder charge associated with the death of the first occupant of the vehicle. We are not debating obviously the tragedy of this incident, Your Honor. Mr. Fletcher on the night in question was actually responding to a work call. That is the reason that he was out on this particular evening. It was not after curfew, it was work related. He works for Ryder, the truck company, Judge. He's a mechanic. And as the court's aware, several years ago, Mr. Fletcher had an issue with substance abuse. Unfortunately, that's an issue that affects far too many people in the community, our loved ones, or sometimes ourselves, our family members, parents, sons, brothers, sisters, children. But Mr. Fletcher has been serving his probation faithfully. He has been supporting his defendants, Your Honor. He is engaged to be married. He has custody of his biological 2 children, and then also takes care of the 2 current children of his fiance, and is now welcoming a 3rd child. They are expecting that child. Mr. Fletcher has employment to return to, Your Honor, in terms of while these matters play out in the judicial system. Obviously, there are, the state seems to highlight Mr. Fletcher's driving record as a reason to change or deny bond in conjunction with the possession charge, which he is entitled to bond on. With regard to the driving record, I would simply say if that driving record, that, by the way, I have not seen certainly a certified copy of any driving record of Mr. Fletcher, but I have no reason to doubt Mr. Coleman's representations regarding that. there are certain rules that the court could fashion. Obviously, Ms. Fletcher has a large family here supporting him, who have also been very supportive of the Thomas family since this tragedy. The allegation has to do in terms of Mr. Fletcher's fault in that death and that aggravated assault, which seems like a mighty jump in mens rea there. Your Honor, seems to be that he was traveling at such an excessive rate of speed on the night that when the person who disregarded the traffic safety device and entered a lane, failing to yield right away, Mr. Fletcher then did not have sufficient time to react and stop the vehicle because of his rate of speed. Obviously, we haven't had an opportunity to have our own investigators take a look at any of that evidence to be able to argue it at this point in the case, Judge. I only mention it so that the court is aware of the background context under which these allegations arise, and the sole issue at present right now in the defendant's or in the defense's opinion is whether or not to provide Mr. Fletcher a bond on the charge for which he was serving a deferred adjudication sentence and for which he has not been convicted, thereby, of course, making him eligible for bond in such case. Obviously, Judge, the law has changed in a number of ways, and if this were a case where Mr. Fletcher were some violent person, prone to violent outbursts, aggravated assaults, as the state alleges one of these was, although I just don't understand how you...
I'm not going to get into the legal, I mean, they filed what they filed, that'll be a question for later, so.
The issue here, Judge, is whether or not to grant him bail while the allegations that form the basis of the revocation of this bond come to be addressed by the court. Your Honor, as I mentioned, and I would like to put his fiance on just briefly, his mother as well. And
let me stop everybody. Here's what I'm inclined to do. I am inclined on the two new cases, the ag assault and the manslaughter, to in part grant Mr. Coleman's motion and modify the bond conditions. I don't believe I'm going to increase them because I think I can modify them in a way that will hopefully ensure the safety of the community. What I'm going to do in cause numbers 25 DCCR 0838 and 0839 is modify the bond conditions in those cases and order as a condition of bond that Mr. Fletcher is not allowed to drive, period, ever, any vehicle while these cases are pending. It does concern me the prior allegations with regard to driving. We've got 2010 a crash, 2012 a crash, 2012 maximum speed limit issued, 2013 speeding over 10% over, 2016 speeding greater than 15 miles over, 2018 another crash, 2021 another crash, and here we are with a crash where I'm not going to get into fault, but there is a crash and we've got someone that has passed away and someone that is seriously injured. So that if I'm going to require that, I understand there may be work issues, and that is what it is at this point. That is what I'm going to order in those two cases.
And I could understand that, Judge, but I would point out that the same issues of fault that belie this case We're also uncertain of what.
It doesn't matter to me.
And I
We're gonna
understand
stop
that.
having crashes, no matter whose fault it is. When there's a common factor, and there's the same thing that continues to happen, I can't help but at least have some concern that there is at least some type of fault on some of those. You know, you don't get into that many crashes without something happening, okay? So my job is twofold: keep everybody else safe in the community and to do what's right with regard to you and your rights as well. But I've got to keep everybody safe, and based on that history, at this point, while the case is pending, unless something changes later with further order of the court, you are ordered not to drive, okay? And so I think just by the nature of obviously that order, I'm probably inclined to grant the motion to set a bond in the probation case. And so I am at this time going to set the bond in cause number 21-37809. I'm going to grant the motion to set a bond. I'm going to set the bond in that case at, that's a possession. I'm going to set the bond in that case at $30,000. The condition of the bond is the same. You're not to drive any vehicle. And it doesn't look, I think Mr. Wilkerson is correct. I'm just looking at past administrative hearing that there hasn't been an issue with any type of positive drug screen or anything like that. And
Not administratively, Judge, but he is accused of, in addition to the manslaughter and the aggravated assault, accused of violating his probation with the possession of a marijuana case and also UCW as well.
so what I'm going to require is the condition of that bond on your MTRP case is that you wear a drug patch if you make that bond at all times. You'll have 24 hours from the time you're released to get a drug patch put on. You have to go change it every 2 weeks, on time. It needs to be on there, can't sweat off or whatever. You need to make sure it's on, and it's testable every 2 weeks. Obviously, if there is a positive drug screen for anything in your system, it's a violation of all of your bonds, and you'll be right back into custody with Mr. Coleman probably telling me I told you so. So make sure you stay clean, make sure you get it changed when you're supposed to, and all of that kind of stuff. So that bond condition is the same on all three of the cases. All the bond conditions are the same on all of the cases. No driving and drug patch on all three cases. Anything else?
Just procedurally, Judge, ordinarily, we would defer with these types of charges, new charges, we would defer the MTRP, we'll wait on that and proceed on the new case, particularly with how serious these are. However, in this case, I just want the court to know that we would be looking to go forward on the MTRP first.
Okay.
For a number of reasons. So we're looking to amend that MTRP. We'd ask that it be set prior to a disposition in the new manslaughter or aggravated
And you would be
assault.
intended on putting on evidence of those new offenses in that hearing? I would.
For punishment, the punishment part of it is,
I mean, to prove up the MTRP.
we have other that we with the MTRP, particularly the possession of marijuana, also the UCW, but there very well may be some additional testimony about those circumstances surrounding
So there-
aggravated assault and manslaughter.
There obviously appears to be some additional information, or maybe just because of the size of the cases, I haven't had an opportunity to review everything.
Yeah,
But
so-
there are some allegations that I'm hearing have not been at the forefront.
So let's do this. Obviously, you need some time to get all that information. If there's going to be an amendment, if you'll please take care of that quickly, make sure anything that's alleged in that Mr. Wilkerson gets any discovery with regard to any new offenses or alleged offenses that you intend to put. That way you guys can both have all the information. Mr. Wilkerson can do what he needs to with that information, and we'll set it for an announcement. And then we'll kind of go from that announcement on where to go next with regard to either the new cases first or the motion first. All right, sound good? All right, thank you. Y'all are excused. And thank y'all all for being here. I don't want anybody to think, I feel like we could cut it a little short and get that taken care of. All right, you go back with the bailiff.
Thank you, Your Honor.
Yes, sir. I've got an order